belong to a future process, because in this meeting, if you like, want to separate the lines here. Who's going to do what, when, and move on. Then what needs to be done and how it's going to be done goes into a little bit of further details. And some of your submissions are going into that, and it will be a difficult one to get all of those issues discussed here. So, for example, you're raising the issue about representation. That will come later. You're raising the issue about the existing code of conduct. That will have to be tabled for something that will be a process beyond this kind of meeting. So there is space to deal with some of those, but we're not looking at changing anything in terms of the existing recommendations. All we want now is to see whether we understand each other, because if we do, then we've got a way forward. If we don't, then we're stuck. And that's why we need to actually clean the issues up. And that's why for us, it's very, very important to be very meticulous about who is discussing what and where are we with that particular issue. So thanks very much for your continued participation. Now, let me get back then to the process. Now, effectively to the members of the committee, if there are no issues, I'd like the CRL committee to commission to respond to the issues, so that before we get to talk to the Section 22 committee, the Section 22 committee will come after. But for now, I just want us to have an understanding. Part of what we are trying to do as the committee, as the portfolio committee, is to remove the suspicion in the process. And part of removing the suspicion is to separate the issue about regulation to the process of the code of ethics, the development of the code of ethics. We need to separate those two. Now, as a committee, we agree that the code of conduct should proceed, that the issue of legislation is an issue that will be discussed separately later, but it's not part of this Section 22 process, so that no one must then raise the question of this process is about regulating the church, because it is not. And so that's what we want to separate. Now, the other issue that we believe needs to be clarified and dealt with is the question of the Section 22 committee. If it is not representative, then we're going to talk to the committee and talk to how we can then get that corrected, so that as we go forward, we can deal with a committee that is not being questioned in terms of its inclusivity and legitimacy, in terms of whether it represents the right people or excluded others. So we'll deal with that with the committee. But before that, we need to be able to make the point clear that the CRL Rights Commission is not going to be part of the Section 22 process as it unfolds. Now, from the point of view of the committee, we would want the CRL Commission not to be part of it. From the point of view of the commission, you say you are not part of it. But the comments that have been referred to in the media are actually quotes of the chairperson about this process. So we now need to be clear that there is not going to be any such comments, because that's really where the grievances are arising. If you, as commission, are not involved in comments about the Section 22 committee, about the code of ethics, about regulation, and so on, then there would not be an issue to complain about. Well, that's where the complaints are. So if we separate these, we have to actually then ensure that the commission makes no public statements or comments about this process, because that's where the complaints are. Because if they do, then it's forcing the committee to go into an investigation of the complaints around it. Whereas, as far as we can see, the code of ethics can be developed by the Section 22 committee without much involvement or comments or issues arising from the commission. I think whether this is an artificial separation or not, but it has to be seen to be separate, because then there's no need to deal with the grievances. There's a new set of grievances that are coming from the Section 22 committee. We'll talk about them later. As Honorable Swart was saying, that I've been to meetings now, I've got letters and so on. We'll deal with that later, because it's correcting a process which otherwise is not supposed to have the first problem of doubt as to what its mission is. If it's clear that we're not dealing with the regulation of the church, then it makes it easier to move forward. But also, to do so, we need to make it clear the CRL Rights Commission is not going to be the one that's conducting the process and commenting on the process. If that is the case, then we separate the issue. There's no need to discuss the grievances. But if that continues, then of course we're going to go and investigate those grievances. That's the issue. Now, can I get the commission, and I'd like the commissioners all to make their comments. I'd like to hear their comments. We can start with anyone. It's up to you, Mr. 𝐬𝐮𝐬𝐫𝐢𝐛𝐬𝐜. It can be you starting or the other members starting. There's no problem. There's no order. But we'd like all of the commissioners who are here to make their comments about this whole thing. So you can please, I'm going to have to call members if they don't raise their hands. Please proceed, Honorable 𝐶𝐨𝐺.
Okay, thank you, Honorable Chairperson, honorable members. I would like to assure the members that since October 2, 2025, as the chairperson of the CRL Rights Commission, and also commissioners, including the deputy chairperson, all media-related interviews have been done by Dr. John Maloma, who is the chairperson of the Section 22 Committee for Christians. We stopped commenting and allowed them to comment. The only time when we're dragged into commenting was when there were untruths around the resignation of Professor Musakulu. But even at that time, Reverend Dr. Maloma was with me because he knew more, as the members, they knew more what had been happening in the committee since I was not there. They only invited me once when they told me that there's a crisis, but otherwise would like to assure the members of the committee and the honorable chairperson that if you can check the dates of the comments, they are 2017, 2018, 2019. None of the clips that I've seen, that we'll probably see, are from 2025 or even 2026. So we have no problem in saying the committee itself, because we know very little about what is happening with the committee, which I hope they'll do their presentation later and they can clarify this issue later. It's the people who are from the administration of the CRL Commission who are helping facilitate the process as a secretariat. But as the commission, in terms of commissioners, we are not involved. And we can, I'm hoping today we can clarify that in front of the committee, the Section 22 committee, that I only come in when invited, or when there's a crisis, or when there's a financial issue in terms of compliance, those types of things that are still the responsibility of the CRL Rights Commission. Be that as it may, Honorable Chairperson, will give the Honorable Chair and the Honorable members assurance that as they are moving from province to province, we have never been involved and we have no intention of being involved in the consultations of the process as they consult other religious leaders. Honorable Chair, honorable members, as the CRL Rights Commission, we welcome the opportunity to engage with the Portfolio Committee on COGTA regarding its report on the engagements with the religious community on accountability mechanisms for the religious sector. The Commission wishes to express its appreciation to the Portfolio Committee for extensive consultations undertaken with the various stakeholders and for the constructive manner in which it has undertaken with the various stakeholders and for the constructive manner in which this has been facilitated, the whole dialogue on this important constitutional matter. The committee's report reflects a shared commitment to strengthening constitutional democracy, protecting the rights of cultural, religious, and linguistic communities, and promoting accountability, ethical leadership, and social cohesion. The Commission recognizes Parliament's constitutional oversight role and values the ongoing engagement between the Portfolio Committee and the Commission as an important component of participatory democracy and cooperative governance. It remains committed to working collaboratively with Parliament, religious communities, and all stakeholders in advancing the constitutional principles of dignity, equality, freedom of religion, transparency, and accountability. The Commission further notes the broad areas of consensus identified by the Portfolio Committee, particularly the collective commitment to preventing abuse within the faith sector, strengthening ethical standards, promoting self-regulation by religious communities, and safeguarding the rights and freedoms guaranteed by the Constitution. Accordingly, the Commission respectfully submits the following response and observations for the Portfolio Committee's consideration. We fully welcome the report and we are committed to the role of both Parliament and the Commission as important, and it's timely. The report demonstrates Parliament's commitment to protecting both constitutional rights and religious freedom while addressing abuse within the faith sector. The Commission reaffirms that it remains fully committed to promoting and protecting cultural, religious, and linguistic rights as provided for in the Constitution and the CRL Rights Commission Act. Importantly, the Commission states unequivocally that the Commission has never sought, nor does it possess any mandate to regulate religion. Rather than dismissing objections, the Commission acknowledges that some religious organizations have genuine concerns and perceptions regarding the Section 22 process. Whether or not those perceptions are legally correct, they deserve respectful engagement. The Commission expressly recognizes Parliament's constitutional oversight responsibility and mutual relationship on the participatory democracy journey and process. Rather than viewing oversight as interference, the Commission welcomes constructive oversight that strengthens public confidence and independence of the Chapter 9 institution. This aligns with both the Commission and the Committee's observations regarding complementary constitutional responsibilities and public participation efforts. The report suggests that misunderstandings have contributed significantly to the dispute. The Commission will undertake to do the following: will improve communication and clarity to its constitutional and legislative mandate so that there's clarity as to what it is that constitutionally and legally we can do or not do. Will simplify explanations of the Section 22 process in terms of the CRL Act of 2002 and our 2017 report. Will ensure stakeholders understand that the process promotes self-regulation rather than state regulation. Will engage more extensively before important decisions are implemented, which is exactly what the Section 22 committees are currently doing throughout the widespread consultative processes as discussed below. The Commission undertakes to broaden consultation with all sectors of the religious community, including those who have expressed reservations. The message will be clearly that no religious community should feel excluded from shaping a process intended to benefit all religious communities and to reclaim their freedom of religion. The Commission would like to state that the original concern remains the protection of vulnerable people against abuse, neglect, and misuse of religious practices and governance. The CRL Rights Commission report and the 6th parliamentary report, the 𝐾𝐽 report, recommends that there should be a move from institutional disagreements towards practical solutions, including ethical community and religious leadership, self-regulation and governance, protection of vulnerable persons and communities, accountability and responsibility, respect for constitutional and human rights. This is also consistent with the committee's concluding observations. The Commission remains committed to serving the community and public interest and will continue working collectively as an institution. This is based on institutional accountability rather than individual disputes. The Commission is pledging its willingness to participate in any future dialogue facilitated by Parliament within the bounds of the law. Trust between constitutional institutions and faith communities is itself an important constitutional objective. The Commission acknowledges that the process has demonstrated that, despite differing views on process, there is broad consensus that abuse has no place in any religious community. We therefore commit ourselves to working collaboratively with Parliament, faith communities, and all stakeholders to strengthen ethical leadership, protect constitutional rights, and promote social cohesion. The Commission does not attempt to rebut every criticism contained in the report. The report itself records that there's broad agreement on the need to address abuse, support self-regulation, and develop a code of ethics. The Commission acknowledges that today's discussion with the Portfolio Committee is to restore confidence, reassure Parliament, reassure faith communities, demonstrate institutional responsibility, reaffirm the Commission's constitutional mandate, and position the Commission as a partner in finding solutions rather than as a party to a dispute. The Commission would like to thank the Portfolio Committee on behalf of the victims and the survivors in sacred spaces for these recommendations, because we feel these are the recommendations that they have been crying for. And those that we've discussed these recommendations with are saying this will solve the problem of violations, especially spiritual, emotional, and sexual violations in the religious sector. So we would like to thank the committee for these recommendations and would like to say, personally, as the chairperson of the CRL Rights Commission, I will be responding formally to the allegations made and will be dealing with them and will then submit to the Portfolio Committee the responses thereto. Thank you very much, Honorable Chair, honorable members.
Now, thank you very much, Ms. Kaluva. You seem to have quite a well-written submission, but we don't have the copy. So please share that copy with us. Thank you for your comments. May I invite Commissioner George Mahlangu to comment? I'm going to go through the list. Please, let's have Honorable, the Deputy Chairperson.
No, thank you very much, Honorable Chairperson and honorable members. Indeed, we welcome the committee's report. I think it goes a long way in ensuring that we close the gap in terms of the issues that the committee has been faced with. And I can also assure this honorable committee that we have never been part of the Section 22 committee. Personally, I haven't attended any of the meetings in terms of the consultations that have taken place in 3 provinces, I believe, so far. And like the chairperson, I've only participated in dealing with issues related to the finances, which is part of our governance mandate in terms of the terms of reference. I must say, Chairperson, that there are a lot of issues that need to be dealt with in terms of just issues that touches on misinformation that I think form part of some of the grievances that the committee has received. And as the chairperson has indicated, that we will duly respond to those. And there are maybe perhaps also other issues that we will then discuss as a commission, so that when we respond also, Chair, as part of the plenary perspective from that side. Chair, I think I will pause here. If there are other issues that come up, I will duly respond, Chairperson. Thank you very much.
Thank you very much. May we have Commissioner Govender to comment through the list. So please get ready. Commissioner Govender.
Thank you so much, Chairperson. The Commission appreciates the concern raised by regarding ensuring that all voices within the Christian community are heard, as well as other religious communities. This is obviously a very important principle because the religious landscape in South Africa is so diverse and includes established denominations, umbrella bodies, independent churches, emerging ministries, and many smaller faith communities. However, dear Honorable Chairperson and members of the committee, it is important to distinguish between a representation on a Section 22 committee and the broader consultative process undertaken by that committee. It would be practically impossible, Chair, and perhaps even counterproductive to constitute a committee that includes every individual church organization in South Africa. Such a structure would become unworkable and would compromise its ability to conduct meaningful deliberations. The approach adopted by the Commission was therefore to constitute a representative body comprising recognized umbrella structures and significant religious formations with a specific responsibility and mandate to ensure that they undertake extensive consultation with the broader Christian community. This includes both independent churches and umbrella organizations, ensuring that diverse perspectives, concerns, and recommendations are brought into the process. The purpose of the Section 22 committee is therefore not to become the final voice of only those who sit on a committee, but rather to facilitate a process through which the collective wisdom, experiences, and concerns of the wider religious community are captured. With regard to other religious groups, it has been taken into consideration that there are multi-faiths in this country. So therefore, a Hindu Section 22 committee was appointed through a consultative process. So a meeting was arranged, organizations were invited, and nominations were requested for them to appoint a Section 22 committee. The CRL Commission received a number of nominations and a committee was established using members of umbrella structures. The seeds were planted, the foundations were laid, and they now have developed their own roadmap to go and consult in the broader South African society with regard to the Hindu faith sector. Similarly, other similar structures will be done with other faiths. So that is my submission, Honorable Chairperson and Honorable Committee members. Thank you so much.
Thank you very much, Commissioner Govender. Although I do worry that you might just be bordering on somehow being too defensive, because no one has said we want every religious body to be represented. So I don't like to hear a response that suggests that what you have done it because you are trying to, because in any case, not all the religious bodies will be represented. That's not quite the issue. And I do want us to clarify that it's not quite the issue, and I don't want us to get embroiled in that discussion. Maybe later we will get back to this point, because it is at the core of what we're trying to resolve, but it should not be done in a manner that makes it difficult to look for a solution. I'm a bit concerned there, but we'll come back to that point later. Nevertheless, let's proceed. Can I have Commissioner Mantula? Can I just hold for a while? Honorable Mkhaliphi, you want to come in before?
Oh, thanks, Chair. I raised my hand before you make that point because I wanted to get a clarity. Are we embarking on the public hearing? Kanti, that is not our understanding as a committee, but you have clarified the Chair. Thanks very much.
Okay, no, thank you very much. I responded because I think all of us understand the same way. I'm not quite sure if Commissioner would understand what, it sounds like when we sit from our side, it sounds a bit different. But in any case, we'll get back to that. But thanks for raising the point. Let's have the next Commissioner, Mantula.
Chairperson, thank you, and apologies with my camera. It seems it is my gadget, but just to acknowledge this report of the committee and the process that we have taken since last year, Chairperson. When I look at the report from your concluding observations to the summary, Chair, I think that was detailed for what must be done by the Commission, what should be done by the religious community. And considering that the issue of the freedom of religion is a very sacrosanct right, it should be protected, it should be defended by those who are pursuing all those rights. And from the report also, Chair, what I picked up with the issue of that you are raising in terms of the recommendation on reform of Section 22 committee, I think I've been consistent, Chair, and with other members of this commission that the interpretation and understanding of Section 22 is very key in terms of the legislative mandate of the Commission. And secondly, Chair, the trigger of the 2017 report, the lapsing of the report and the revival that has go to where we are, I mean, it has pushed us to where we are today, talking about the peer review committees or an ad hoc Section 22 committee. It can be semantics, but from what the committee has found, Chair and the members of the committee, is to have this a clear session of interpretation also assisted by your legal service, which they have already said that the Section 22, there's nothing wrong about it. But I have my different view, Chair, in terms of the interpretation, where I still insist that you cannot have a Section 22 without members of the Commission. If you read the spirit of Section 22 and the drafters, they've made sure that the committees of Section 22, they play oversight. Even if you have a mixed members or you have staff in Section 22, you need to have members of the Commission as part of Section 22. The second aspect, Chair, on the recommendations, I felt that yes, on the issue of code of ethical conduct, the recommendations of the 6th Parliament of 𝐶OGTA Committee emphasized on that, Chair. You will recall that that report also emphasized on the issues of ethical conduct that should be developed by the religious communities. And the issue, Chair, that I thought the committee would have thought of, the role of National Consultative Conference. I thought the committee should have looked at that if there was no enough public consultation on this process. More so, there were issues around the terms of reference of this committee, which is Section 22. I thought the committee should have thought of a recommendation of that. The committee and as a parliament of the people and the commission as an institution supporting participatory democracy. We could have thought of having a joint public consultative conference to look at this report of 2017 and its validity in 2026, look at the current challenges that are pressing in the religious communities, whether on governance, abuse, and further, Chair, look at the questions of now, do we need a legislative muscle or mechanism to deal with such acts or conduct? Finally, also, members of the committee, when I looked at the concluding summary, I think concluding summary, Chair, as I was joining late, there was a challenge with the link actually. When you were reading the issues of how the parliament, parliament cannot lay dormant and wait for the court process. We do fully agree, Chair, that there is a need for both the committee of the parliament and the CRL to constantly engage with communities if they are not happy. And that's how I feel that the role of the parliament is, yes, to play oversight. The CRL also, in terms of Section 181 of the Chapter 9 institution, has a mandate of being impartial, independent, and effective. And that's where I see the role of Parliament under Chapter 4 of our Constitution is very clear of what should the committees do in Parliament in terms of assisting the Chapter 9 institutions. So overall, Chair, like I said, I share the sentiments of the committee, and I will hope that we will reach somewhere a crossing point or a middle road where we are able to can resolve these issues. Thank you, Chair.
Thank you very much, Commissioner Mantula. We would have assumed, though, that you had received the report much earlier to look at it. I hope that you did. Part of the issue of Parliament raising the question of the separation of powers, we're actually raising it because it was your commission report that came with that matter. We were not stuck in terms of what role we have to play, but it came from your report, if you recall, that the Parliament must respect the separation of powers, and we thought that your understanding was not really the same as ours on that, but that's all on the report. Can we take the next Commissioner Mapanka, please? We don't have Mapanka. Let's move to Commissioner 𝐬𝐻𝐾𝐿.
Thanks for the opportunity, Chairperson of the Portfolio Committee, and to all other members in attendance. I read through the report that came from the Portfolio Committee, and I think it's very clear on the whole, and the recommendations and the observations seem clear mostly. And I think the Commission, and I being one of them, the commissioners, are in agreement with what is written in the report. I think we agree largely. There could be just a few differences of semantics here and there. And it's important indeed that both the Portfolio Committee and the Commission keep consulting one another on the important issues so the misunderstanding can be minimized. On the whole, I don't think, I think I've been represented by what the other members have articulated, and those differences that could be there need to be addressed so the way forward is easier. Thank you.
What are those differences, Commissioner 𝐬𝐻𝐾𝐿?
I think the differences are in the understanding of what comments maybe are made by the members that are challenging the Section 22 section. Oh yes, I forgot to address one little issue, the fact that we do not attend Section 22 meetings. We only attended the launch. I attended the launch, which was held on the 8th of October last year. And that's the only time I met with the members of the Section 22 Religious Committee. I do meet them time and again in other gatherings which don't have to do with the Section 22. But on the whole, we never attend their meetings. The differences that I'm talking about is where utterances are made about the Commission, which I think are largely untrue. I've come across those when I look through the media, but on the whole, yeah, that's, maybe I should leave it at that.
Yeah, maybe you should, but the difference is, as far as we are concerned with the Portfolio Committee, we don't disagree, we're not having disagreements with the CRL Commission. So we don't have a misunderstanding with CRL Commission. We disagree with certain things. So it's not that we misunderstand each other. The issue of misunderstanding has been what the CRL is saying it's doing, the Section 22 process and the sector. That's where the misunderstanding is. What you as commission were doing, there were those in the sector who understood that you were actually trying to regulate religion. That's where the misunderstanding is, and that's what we're dealing with. So we're not like there's much to clarify between you. We just simply disagreed with the commission when you said we must stay on our lane and we must leave the issue in court. And we're saying no. We're not agreeing with you on that. But insofar as misunderstanding, what we are clearing is a misunderstanding that arose out of the Section 22, not that the committee has got a misunderstanding, but the sector and the commission and the Section 22, that's where the misunderstanding is. Honorable Mtolo, thank you very much. Commissioner 𝐽𝐿, we'll come to Mosala. Honorable Mtolo, before we proceed.
Thank you, Chair. Now, Chair, I wanted to propose actually the way forward in terms of this process. Instead of allowing all the commissioners to comment, I'm not checking a meeting from you, Chair, but I wanted to propose a way forward. If actually, because the chairperson gave us a detailed report, moving forward, just to check with the commissioners if there are any comments or issues that they would like to add, then actually pointing each and every commissioner to speak. I will propose that actually allow them if there's any addition or issues of diversion that actually they have, and then we move forward. So just to check a question, Chair, which I think it will help us for record purposes. I would like to raise this question: if there was any interference from the side of the CRL Commission to the work of the Section 22 committee. I think that will help if there's any member who actually have any complaint or any view of on any such view with regard to interference in terms of the work of the Section 22 Commission. So if we could just get that indication for record purposes, I think that could help Chairperson as well, so that we'd be able to move forward. Thank you, Chairperson.
Okay, I'm going to first start getting Mosala and then Peto. We can follow the approach there. If there's any other commissioner that want to say anything following that submission. But let's start with Honorable Taiposh.
Thank you, Chair. Appreciate it. Greetings to the chairperson of the CRL Commission, the other commissioners of the CRL Commission, and the ministry that's present, and also to all my colleagues. Chair, I listen to the commissioners and what they're saying, and then I listened to the report from the chairperson. A very well thought through, very well articulated report in terms of this in terms of the response to our report. However, it seems like, and this is what's coming out whilst listening to the other commissioners, there are commissioners that have more things to say, and there are commissioners that doesn't necessarily agree with what the chairperson's report is saying. So I don't know, I don't want to make a statement like this, but it seems like not everybody is in agreement, or it seems like the report from the chairperson was not discussed either or fully accepted by all the commissioners. So I don't know which it is, chairperson, but that's my impression. So maybe we need to get the the CRL Commission to really, to discuss their own report and get onto one page before they submit the report like that to us, because it seems like they don't agree on the things that's there. Thank you, Chair.
Thank you. Commissioner Musala.
Thank you so much, Chair. And once again, a very good morning to you.
You just disappeared. We'll take Commissioner Peto. We'll get back to you. Peto, you're muted. You are muted. We see your face. No, can't hear your voice. You are still muted. You are no longer muted, but your gadget is faulty because we can see your video and your mic is on, but you can't get your voice. You will have to get a bit of assistance now, because you are certainly not muted, but you are not audible at all. Okay, I think you need to find a way to get yourself assisted, get some neighbor or something to help you through. Commissioner Musala, you disappeared. I think you got thrown off the platform. Are there any other members of the commission who want to make comment? Any other members? Take into account what the members have just suggested. Any other members? We will then proceed. We will then proceed. When you come back, we will give you space to make your comment. So let's come back then to say, so between us between the commission and the portfolio committee, we are agreeing that there will not be the participation of the commission in the whole process of the Section 22 process. We also would agree that there should be no comments or utterances that refer to this whole process, code of conduct, litigation, regulation, and the Section 22 process. We'll leave everything to the Section 22 process. Now, I don't want us to go too much into, did you not participate? Did you participate? Because there were some of the issues that were raised. For example, there was a video that was referring to the chairperson saying something about the president. Why, what will people say when the president meets these people and so on? So there are obviously background issues at the back that are not helpful for us. And the point we're making here is that we do not want the portfolio committee to be settled with issues arising from the commission in relation to Section 22 that will ultimately require the portfolio committee to intervene, because that is derailing the process of trying to find a solution towards the protection of abused congregants. The issue of development of the code of ethics, ethical conduct, which all the leaders have agreed to. And so, because they have agreed to, let's just remove anything that's going to cause unnecessary disagreements, because the process is clear. The other issue we're saying we are removing is the issue of regulation. That matter will be dealt with as a separate matter, separately, after all of this has been done, to look as to whether there are gaps in the code of ethical conduct that require legislative reinforcement. That is how we want to look at it. And therefore, there will then be a process which we must go into that must address the question of representation. That's why my concerns were on Commissioner Govender's comments, that there has to be a corrective measure to ensure that there's inclusivity and that there is participation broadly, so that there are no sectors or faiths that feel that they are left behind. So we need to get to that kind of point. Now, we need to go into more specifics with the committee beyond this point. And those issues, we now need to go into what do we think needs to be done. From one point of view of the committee, of the portfolio committee, we would need to close the issue at a point where we are in a position to convene a meeting of all those religious leaders, so that we will then hand over the process to say this process of the Code of Ethics continues, that the religious leaders will need to correct the representation, and that that process needs to unfold in a manner with certain timelines and so on, and that the commission has to also look into the issue of what restriction or constraints we have on resources, so that there's a clear guide as to what can be done and what cannot be done and so on. Now, there are a number of things which are arising even on the Section 22 committee process. And I said we'll hold on to those and talk about them when we talk to the commission. So I'd like to just, before we move to deal with the Section 22 committee to participate, if our understanding on this matter is all aligned, and I want the members to indicate that, and then we can proceed from there. Honorable Swart.
Chairperson, thank you for the opportunity. I just wanted clarity. Again, bearing in mind I'm not a member, and I really appreciate the opportunity to engage. I do think it's very important for you to engage on representation on the Section 22 committee, and I think that was part of your opening comments, and I believe we will reach that stage. That's a crucial phase. But may I suggest you rather flag the issues regarding the complaints. The chairperson of the CRL Commission indicated she will respond formally, and I would suggest that it needs to be considered when the chairperson responds to those complaints. I did note in the report that they said they were formally tabled, and I would strongly suggest that you flag that. But I do understand you don't want a distraction, but it is an issue. You don't want a distraction, but it is an issue that may need to be dealt with, probably needs to be dealt with once the CRL chairperson has responded in writing. I do also appreciate your concerns about the representation of the CRL on the Section 22. I'm also mindful of the prescription of Section 22, and I think one of the commissioners pointed that out, that it does dictate there's an interpretation that one might need to get legal advice on. But I appreciate the process of going forward would necessitate right now a consideration of the representativity on the Section 22. And may I mention, we weren't aware, and you asked pertinent questions about the number on the Section 22, the representation on the Section 22. I think it must be a matter of concern that the Nazareth Baptist Church has, for example, 6 representatives on the Section 22, if my information is correct, and I stand subject to correction. So I think the point you make about broad complaints about the representativity, and that's aside from the court action. We're not discussing that. That's something else. But I think that is a very pertinent issue that we need to discuss, and I welcome that engagement that you've led us in that regard. Thank you, Chairperson.
Thank you very much. Yes, Honorable Swart, I didn't want to comment on it, but it will require not a discussion, but an engagement with our legal team to look at how to deal with the question of the interpretation. But I wouldn't like us to get dragged into that discussion in this meeting. We note that would need to be put up. And it's only important because we, at this point, are wanting to separate issues, and therefore we would like to be clear that the CRL Commission is not participating in this process, and then we can move from there. But then we will look into the legal interpretation on that. But having said so, I'd like the members to come back and see whether there are any issues that they would like to raise at this point, because I'm not very keen to be dragged onto going too much about the chairperson responding to this and that and those allegations. And I'll tell you why that is the case. The reality is that we have characterized the issues as a misunderstanding. And only if we think we're not dealing with a misunderstanding would we then go into an investigation. Now, if we are not yet investigating, I'm not sure how you can just respond to issues that have not been put directly to you, because what's important is a framework. On what framework are we dealing with these issues? The committee sat through a legal opinion, and the legal opinion said there are two things here. Are you dealing with a grievance that needs to be investigated, and this is the process? Or you are dealing with a matter that you need to first go in, mediate, clear the misunderstanding, then once you conclude that in fact it needs an investigation, then you move on when you know you've cleared the misunderstanding. That is how we've approached the matter. So at this point, I'd like the Commission to work with the committee and not to try and foist to the committee a process that the committee has not yet decided upon, and also to avoid a situation where the committee gets a sense that the Commission is just too defensive instead of listening and trying to solve the problems of the sector. And that's the reason why we had made the comment earlier, and the members rose when Commissioner Cavender had raised certain issues. So I'm saying, are we together as the committee happy to take the next step of going now to get the Section 22 committee? How are we going to get the representation and inclusivity? What are the constraints? What are the issues? Can we take that process from now forward? Because we still want to convene all the religious leaders involved and deal with the issues there. The issue of the National Consultative Conference is something that the minister has got resources to do. So at some point, we would engage and get to that point as part of dealing with this issue. We will put that on the side. It's not right now. We also need to agree on how, when we do the next meeting, how we're going to go about that. But right now, I just want to be sure that we are moving a few steps ahead together as a committee. Honorable 𝐬𝐿𝐫𝐿 and then Honorable Van Zyl. For now, we just want to get the committee members to focus on the issues. Please, Honorable 𝐬𝐿𝐫𝐿.
Good morning, Chair. Thank you very, very much for the opportunity, and good morning to the chairperson of the CRL and the team Balake. I just hope that I'm clear, Chair, because I'm again, unfortunately, in the car driving. But firstly, it was a point of clarification. Okay, thank you, 𝐾𝐨𝐧'𝐿. Firstly, it's a point of clarification, because if the chairman can help me understand, the chairperson, because I think I heard her, but of course I stand to be corrected, saying something along the lines that the lines are becoming blurred as far as our team is concerned, our committee is concerned, between oversight and interference, or something like that. But if I didn't hear properly, because as I was saying, the network is not good, then I will have nothing to comment further. But also my feel as well as I've been listening to most of what I managed to hear, is that it does feel like one wouldn't want this to end up feeling like it's combative, or it's painted into the corner, the commission. Because I think by and large, Chair, we are fully aligned. There's no argument that when we talk about things like protecting the vulnerable, things like avoiding the abuse. I think really the thing that blurred the lines or threw the cat amongst the pigeons, if I may use that term, was the Section 22, where we needed clarity. Because I think if anything, I just think that maybe if it will be very helpful if maybe by this engagement, I may ask the following, just a broader question to the commission, to the chair and her colleagues, to say, look, I mean, from their perspective, when they look at all that has been going on in terms of themselves as a commission, do they feel? I don't know. How do you rate Chair and the team, chairperson of CRL? What is it that you believe causes so much misunderstanding, and how do you rate your level of being understood by the people at large around the CRL, and what would need to be done to close the gap? Because there is no argument that there definitely there is a gap, and if nothing else, it's widening. What is it that you will do? And also to really, most importantly, find that people are embracive towards the CRL, and asking yourselves now, not the questions of oversight from ourselves, because I don't know, I don't believe you could say all is hunky-dory in terms of the CRL with all that has been going on. At times, actually, it gets a bit concerning that too much time is spent, but if it has to be spent, it has to be spent. On rather than spending it on doing what it's your reason to exist, it is spent defending yourselves. But if I can just, that first question is the one that concerns me, because I will comment further whether I hear you saying, because then that also will be at odds with your response in writing. If I heard correctly that the committee, the 𝐶𝐽 committee, the lines have become blurred between oversight and interference. Thank you, Chair.
Okay, thank you very much. We'll come to Honorable Van Zyl just now, but let me clarify one quick issue. I think your concern, the problem was the chairperson made a long submission that she had not submitted to us beforehand, because by right we should have had it before she were to be reading through it, so we could see what is there and follow as she's reading. Now, but just, I think, to quote what she has, I've got the thing and I've sent to you a copy that's opening up. The aspect you're asking about, and I want to read it myself so that you can quickly come back to see whether you still want to take a follow-up. It says the Commission welcome Parliament's oversight role. The Commission expressly recognizes Parliament's constitutional oversight responsibility and mutual relationship on the participatory democracy journey and process. Rather than viewing oversight as interference, the Commission welcomes constructive oversight that strengthens public confidence and independence of the Chapter 9 institution. This aligns with both the Commission and the Committee's observations regarding complementary constitutional responsibilities and public participation effort. I'm reading this, Nkosi, because I want you to see whether if this clarifies what you are asking, then it's fine. If it does not, then you can ask the questions further.
Thank you very much, Kabazela. No, it does. It does. Definitely what I'd heard was not what you've read. I suppose maybe, as you've just pointed out, unfortunately, we didn't have the luxury of looking at the document before coming to the meeting, but that has answered it. I mean, made it very clear. But then I'd like the chair and her colleagues to answer the other one, because I think it's very important about this chasm or this gap, because I don't see it narrowing. I'm the first to admit it's an overarching question, but it is very fundamental to me, especially after having engaged with the different churches as we did and organizations.
No, thank you very much. The reason why I read it is because it's a make or break understanding as to what we are all about. So I'm fine with that. Can the honorable the chairperson respond to the rest of the questions? Then we'll come to Van Zyl. Don't deal with this one now because I've dealt with it, but let's deal with the rest of the others.
Thank you, Honorable Chairperson, honorable members. The issues on the table, Honorable 𝐬𝐿𝐫𝐿𝐫𝐤, in terms of why there is this pushback, it's because it's deliberate. We've looked at it, we've asked experts to tell us what is happening. The issue of us being accused of state regulation, we have explained it many times. The issue of cropped videos, we have explained that many times, and we will be releasing our own social media, the reality of what is the full video, for instance. So there's a campaign out there that I don't think we are skilled enough to deal with, because people are being told untruths about what this Section 22 committee is about. I was hoping, Honorable Chairperson, without usurping your chair, that at least the Section 22 committee chairperson will be given the space, a little bit of time to explain certain things, because we've stayed away from that process. We've stayed away from their interacting with the religious sector. So I'm not at a stage of saying whom have they consulted with and how are the consultations going, as they are going around the country. In the month of August, they'll be in their fourth province, the Western Cape. So I would ask humbly, Honorable Chair, that at least the chairperson be given a little bit of time to explain what it is that they've done to deal with what the Honorable 𝐬𝐿𝐫𝐿𝐫𝐤 is saying, because we've left it in their capable hands to do that.
Okay. No, I wanted to respond to the issues that relate to you with 𝐬𝐿𝐫𝐿𝐫𝐤. I have said the Section 22 committee will come after. So we will get there. We're not there yet. I'm still at this point wanting the members to see whether we're together as we move on. So I'm going to now request the Honorable Van Zyl to come in.
Thank you, Chairperson. Good morning also to all the members and Commission and Section 2 committee members also online. Chairperson, I've got about 7 issues that I wanted to touch on, because I'm sure that raising them now, we will get responses as we go along, as you invite more people to comment. The first thing I think is the independence of the Section 22 committee. I think the first issue is that, and that the committee, us as a portfolio committee, must satisfy ourselves about whether this Section 22 committee is genuinely independent of the CRL Rights Commission. Because if the committee merely operates as an extension of the Commission, it cannot credibly claim to be conducting an independent consultation process. I think we need, we maybe require some clarity on the mandate, the decision-making autonomy, who determines their program, and whether it's free to arrive at conclusions that differ from those of the Commission itself. Then on the public participation, Chair, meaningful public participation, and I think one of the commissioners actually mentioned it earlier, is a constitutional requirement. It's not sort of a box-ticking exercise. And the concerns are very troubling. We have had a mail all of us, as I think, as this committee, PCOCTA committee, to state that in the Eastern Cape, consultation venues were reportedly only announced days before the process commenced, making it almost impossible for churches across the vast province of the Eastern Cape, which I'm from, to organize attendance. And I think in PE it was stated that advertised consultation session was reportedly cancelled, denying participants the opportunity to engage. And those who did attend indicated that most of the time was spent on presenting a predetermined position, leaving little room for genuine engagement. And I think in Durban, there are allegations that registered participants were denied entry despite proof of registration. These are not isolated complaints from one province, but similar concerns emerging from different parts of the country. If these reports are accurate, this cannot be described as meaningful public participation, and I'd really like some comment on that specifically. Then, the court proceedings, Chair, we also cannot ignore that aspects of this entire process are currently before the courts. I think it would be prudent for the Commission to exercise caution before finalizing recommendations or fundamentally altering the mandate of the Section 22 Committee while litigation remains pending. I think us as Parliament must maybe also ensure that its oversight does not inadvertently legitimize a process whose legality is still under judicial consideration. Then in our own report, it states under one of the recommendations, it talks about, and I quote, it says, a reformed Section 22 Committee. I would like the Commission maybe to explain precisely what that would mean. Reformed by whom, under what authority, what changes were made, were stakeholders consulted before those changes were implemented? Does reformed maybe imply changes to the committee's composition, mandate, or independence? And I think we need some advice on that. Then, Chairperson, there are multiple complaints concerning the conduct of the Chairperson of the CRL Rights Commission. This portfolio committee cannot simply note these complaints and move on. Parliament has a constitutional oversight responsibility over Chapter 9 institutions, and I therefore think I believe that this committee should establish a formal parliamentary accountability process to consider the complaints submitted against the chairperson, determine whether there is substance to them, and decide what further action, if any, is required. And then on the 𝐟𝐸𝐿 matter, I did raise it previously, and I'm going to raise it again. The Commission publicly associated itself with 𝐬𝐮𝐬𝐫𝐞𝐬's foundation while later distancing itself from aspects of that relationship. The chairperson said yes, and then she said no. And, previous engagements when they were in Parliament left a number of unanswered questions about the governance, the transparency, and the relationship between the Commission and the chairperson and its external entities. Then the State Security Agency concerns, they also remain there. The Commission must explain what role, if any, the SSA has played in matters relating to the Section 22 process of the regulation of religious organizations. And so I think, just Chairperson, in closing, this committee has a responsibility to ensure that any process affecting the constitutional rights of religious communities is lawful, transparent, genuinely consultative, and beyond reproach. At present, there are too many unanswered questions regarding governance, independence, public participation, and accountability for us to simply accept this process at face value. And I think before any recommendations are accepted, this committee must satisfy itself that the process has been fair, impartial, and constitutionally compliant. I think I'll leave it at that for now. Thanks, Chair.
Thank you very much, Honourable Van Zyl. The issue of the 𝐟𝐸𝐿 Zondi Foundation was dealt with in the last committee meeting. We have actually disposed of it. We actually got the Lottery Commission to give us the report on the matter, and the matter was dismissed. So we can share that. I think you might have been absent, and so we can just share that. So we won't address that in this discussion. The issues you are raising now belong to the next discussion, which is the Section 22 committee process. But the issue that you're raising around the complaints or the grievances that have been raised, I think that matter remains with the committee. And what the committee has to do is to first deal with the issue of the mediation. This is what we clear as the misunderstandings. Then we can then look at the issue of the grievances thereafter. And so that process will actually be with the committee. Then the issue of the court matter, I think we need to look at it as ourselves, because the court order, the court matter does not issue a court order against the processes of the Section 22. It's a matter that's going to be heard in court. Now, the committee, as a portfolio committee, is not involved in the court process. So right now we're dealing with the issue so far as the court, so far as the portfolio committee is involved. So that will have to come back to the committee for discussion. But what needs to be dealt with and clarified in this process are the issues you raise around the independence, the mandate, the governance, the decision-making, the public participation process, the reforming the committee for purposes of representation and closing the gaps. And those would be the issues that we will need the committee process to respond. I will, at this point, then invite the members of the Section 22 committee to give us a quick rundown, a number of issues that need to be covered in this process would include the size of the committee, the basis for the size of the committee. That means that the commissioner might have to come in, the commission might have to come in when it comes to those issues, what are the kind of limits to how far the committee size can be, and the level of representation. How do we deal with the correction of the representation? That has to be dealt with. Then the next question relates to the points that have been raised by Honorable Van Zyl in terms of decision-making, mandate, and so on. And then, of course, we need to talk about the timelines involved, and all of those issues need to be, part of the submission so that we can then engage. What we're really seeking at this point is that there are the issues that need to be resolved is how do we correct the representation in the committee, and how do we, in terms of its structure and the inclusivity, the participation of various groups and so on, then how are we going about with the consultative processes? The issue of the Eastern Cape, we all have reports about it. I have a report. I actually met with those religious leaders who raised the issues, and so various gaps that are raised and so on. Let's talk about that. How do we see the process unfolding going forward? So, Dr. John Maloma, let me give you the opportunity, but we'll open up now for both the Section 22 committee, where there's a need for the commission to respond, they'll have to do so. Thank you. Let's take that process forward from there. Dr. Maloma?
Yeah, thank you very much, Honorable Chair of the Portfolio Committee, Dr. 𝐬𝐮𝐬𝐫𝐿𝐵𝐿, and honorable members. And also thank you to my colleagues that are on the platform with us today. And Chair, if we could be allowed to share with you our presentation, is just graphic so that it gives you a high-level responses that we have prepared for the committee. I must say we have read the report, and we met as a committee to go through the report. And indeed, the voice that is missing in that report is the voice of the Section 22 ad hoc committee for Christian sector. So if the secretary can give us sharing rights, may direct it to Reverend Makhudu Lekhanyane. He is actually my secretariat to help me to flag the presentation.
Okay, before it is tabled, we need to have been favored with the copies. So before you do so, let's have the copies to the members. If we had known, we would have really asked you to submit yesterday, because it's not fair to members to say, here is a presentation, but it was ready, but it could have been shared before we got here. So in future, let's just have the report long before so that we don't go into a meeting and blindsided. So can we get the committee to get the report before you do the presentation?
Yeah. we can share that with the Secretariat, Chair. We really apologize. I mean, we finished this presentation early this morning, but it's not an excuse. So in future, we will definitely submit in advance. It looks like it is there, Chair.
We wait for the circulation first.
Okay. Chair, where must we send it to your Secretariat?
The CRL team should be able to make that connection.
Through you, Chair, Dr. Maloma, you can forward it to myself and Valerie, who will quickly make sure the members get it.
Correct.
Yes, please. I wouldn't like us to start a conversation when the members don't have the copy.
Yeah. Sorry, Chair, we're sending it through. Can I also be allowed to switch off the video and then to improve my network, Chair?
Yeah. You can switch off the video, no problem.
Thank you.
Can we just get confirmation?
Edward at CRL Commission at the same time.
Perrine, are we getting the report?
Chairperson, I'm just waiting for them to send it on to me. I will share with members as soon as we have it.
Still waiting as well from my side.
We will only start when the members have received the copy.
To my email or Valerie, anybody, the two of us will quickly pick it up.
Yeah, it's on its way to you, Dr. Mafaza.
It hasn't come through.
It should be there now.
Not yet.
Yeah, we sent two. Even Reverend Khanyani sent to you. Let me see.
Please check your outbox.
Chair, can I read the question, Chair?
Yes, please, Honorable Mtalo.
Yeah, no, Chair, I want to check a procedural issue here or matter.
Yes.
Can I check whether this report has been shared with the CRL Commission? I'm checking the issue of protocol here. My understanding is, why I'm raising that issue, Chairperson, during the Chairperson's, CRL Chairperson's presentation, was that they are still waiting for Section 22 committee report. I'm trying to check here whether it is correct to receive such a report without actually being submitted to the CRL Commission, just to get an indication whether CRL Commission do get a report from Section 22 committees, whether they are aware of this report or they're getting this report for the first time. If they are getting it for the first time, is that in order? Because while we are having this report as a surprise, I don't want to have a situation or to see a situation whereby as this committee, we are getting a report that hasn't been processed in accordance with protocol. So just to have that indication, Chairperson, thank you.
Dr. Maloma, I'd like to make a comment, and then Mr. Oliver.
Yeah. Thank you, Chair. I think the CRL Rights is right to say they're waiting for reports, because there's an agreed way in which we submit reports to CRL. And our understanding with this presentation is not a report, it's our response as a committee, independent as we are mandated to operate independently to independently reflect on the portfolio committee report and then share with the committee our own experience on the ground, speaking for ourselves. That is why we did not present a joint report with CRL. The CRL submitted its report. We are making our presentation, and CRL does receive reports. And in this presentation, we'll demonstrate that from time to time, we do give reports as per our consultation plan. Thank you, Chair.
Okay, Honorable Ntolo, I think we should hold it. I'll tell you why. Because we did not ask for a report from the Section 22 committee. We just wanted them to respond. And the questions that we want them to cover are some of the issues we raised now. But there will be a point at which we need a formal report. What have you actually done and where is the report, and let's get it properly. That way, the report will have to be done in the way that you are raising correctly about the protocol of submission, because at the end, the committee responds to, the committee is accountable to the commission, and the commission is the one that must come and give us the report. At this point, because we're trying to clear the lines, we just want the commission, the committee also to give us answers on some of these issues so that we can see which way and how we guide the process. But your process in terms of future reports and the protocol of submission, we won't get a surprise report that comes to the committee and the portfolio, and the commissioner says the commission says we don't know about it. That you shouldn't be bringing it here. When you come here, you must have the report of stuff that's happening under your watch, in your jurisdiction. So you're quite correct. So I think that's a warning for future so that the protocol never gets broken. But right now, we are solving the problem. We are giving you the approach of the committee on this matter. We want you to tell us what are you saying about it. Now, your submission, because you prepared it late, we don't have it, but we do need to have it before you actually table it, because it's now in writing. It's the same issue we're raising with the chairperson. We didn't ask for a written report, but now that she had something in writing, she should have shared it with us. So it's the same issue here. Now, yeah, I think we have received the report. The nature of this report, the nature of this submission is such that we should have actually got it a few days before. It's not the one that you can consume on hoof as we are doing now. And so I'll allow members the freedom to determine whether we want to go into details about this or whether we'll redo a proper discussion about it, because of the complexities that I can see from the distance. So that's fine. The members now have received the report, this presentation. Please proceed, Dr. Maloma. Sorry, just hold on. Honorable 𝐬𝐻𝐫𝐿𝐵𝐻𝐿. Please unmute. You're muted.
Thank you very much, Chair. Chair, I just want to raise this issue now. We are busy for a long time. We haven't proceeded very much. This report that I still don't know whether it's a report or a response, but in the form that it's been submitted now to us, it's a report that hasn't been to the Commission. And I think it's not fair to all of us to work through this report. I can't read while they are giving their response and then put this in context with everything else to ask questions that will bring us clarity. So I would propose that we have time to look, to read this report and decide whether it's a report or a response, first of all. And my proposal would be to postpone this report so that we can have a good reading of it and a full understanding. Because up till now, from where I am sitting, and I've been in the last meeting, there's a lot of things that we've already decided that we have to redefine this morning. And this is all that we've done up till now. Thank you, sir.
Thank you, Honorable 𝐿apu-𝐬𝐿𝐾𝐿. I've got lots of sympathy with your concern because, as I said, looking at it, it's not the kind that you can consume on the hoof as it has happened. But let me allow the committee, the Section 22 committee, to just do a response broadly on the issues that we have raised. Now, if you want us to go through this presentation as the details, I can say now, we will need another meeting. But let's just table it and let's hear the issues. And then, but I don't know, we have the time and the focus and the inclination to a very complex presentation of this nature for purposes of what we wanted to do today. So let me I'll give you about 15 minutes, walk through the thing and tell us what's your response on the issues we've raised. And presentation is fine, but now that we've tabled it, we're not going to discuss it in detail, but we do want to hear what we've got to say. So the Honorable 𝐿apu-𝐬𝐿𝐾𝐿 is quite correct. It's a very intimidating, detailed and complicated report that we would like to take our time going through it. But nevertheless, we still need your response. Please go ahead.
So you must get familiar to how we do.
Thank you very much, Chair. Upfront, I must confess that we are pastors, we are church leaders, and we understand only the language of our colleagues in the field. And as far as the Section 22 committee is concerned, this is not a report, it's a presentation. And as the Chair has asked, I'll go through it quickly. There's a way in which we submit the report in a narrative form. This is a presentation, a high-level a presentation in terms of our response to portfolio committee. Let's go to the next page. Yeah, Chair, I won't even elaborate too much on the table of contents, but we're covering 7 points in terms of responding to the committee's report. So I'll go straight into the presentation. Chair, having read the portfolio committee report, and I think also listening to you, we start from a shared premise, which you emphasized quite repeatedly today, that indeed between CRL Rights Commission and Portfolio Committee, even the dissenting religious leaders, because I think the report of committee relies heavily on those who are dissenting. There's a consensus, and this is based on all 52 submissions to the Portfolio Committee, that no stakeholder opposes an ethical code of conduct. We have noted that. However, the challenge is that the conflict lies entirely in the how, the mechanism, and not the necessity. So there seems to be a consensus that accountability does not weaken religion. It protects the vulnerable. So that is what we picked up from the report. Next slide. Yeah. So explaining also, I think it's important to explain the broader Section 22 ecosystem, because we note also from the report that there seems to be an interchangeable way of using the word religion, and sometimes it tends to confuse matters. So from the Section 22 ad hoc committee for Christian sector, we need to put that into perspective, and I think some of the commissioners have mentioned that we represent a particular sector within the religious landscape of the country. We are a Christian sector, Section 22 ad hoc committee. So that's what we represent. The religious ecosystem is very complex. We have Hindus, we have Muslims, African traditional religion, Jewish sector, Rastafarian, and many others that we don't have time to elaborate on. So the reason why there's this segmentation of our religious space is that designing for distinct theological architecture is very critical, because you can't have the one-size-fits-all approach to dealing with issues of ethics within the religious sector. Imposing a single framework, we argue that it is theologically inappropriate, is practically unworkable, and procedurally unfair. So we commend the Commission for the wisdom to segment the religious space in our country so that we have a sector-specific rationale which actually covers the landscape of our country's faith. Because we are theologically different in terms of our foundations, we have unique governance histories within our religious space, and we have got specific vulnerabilities. So that is what we want to commend the Commission for having done. And we continue to say, indeed, one-size-fits-all approach is theologically inappropriate and is procedurally unworkable. So we compare the two, one-size-fits-all and a specific sector approach. Based in terms of theological dimension, as I've said, one-size-fits-all imposes foreign theological frameworks on distinct traditions, whilst the sector-specific is grounded in each tradition's distinct sacred text and teachings. Practically, the one-size-fits-all fails to address unique vulnerabilities, varied institutional histories. Procedurally, it's unfair. It risks centralizing control without context. Whereas this one that is sector-specific is tailored to specific governance structures, cultural nuances, and linguistic context. It ensures meaningful participation within the stakeholders' own faith context. Next one. So now about the Section 22 ad hoc committee for Christian sector. I think, as I indicated, we are really thankful that the committee has given us an opportunity to come and do the presentation. So we were established in October. 1st of October, we inducted, and then 2nd of October, we were publicly launched to the committee in the process or in an event where the chairperson of CRL proclaimed and declared to the public at large to say, today she launched the committee ad hoc committee for Christian sector, and she allowed us to venture on our own. We were given a mandate. Our mandate is to conduct broad consultations and facilitate dialogues that will result in mechanisms and strategies to facilitate ethics and accountability. The approach that we embarked on is a peer review mechanism, not state regulation. And we need to say a word, Chair, about our representation. It has been also raised here several times. There's a query about the representativity of the committee, and we wish to say the following. The committee does not claim to represent every church or every Christian tradition. It represents a broad spectrum of Christian organizations that agreed to participate. Its mandate is to consult widely, including churches not directly represented. And through the provincial roadshow, every church, pastor, and congregation will have an opportunity to shape the final framework. I think that's very, very important. And further on representing the
I'm sorry, Dr. Maloma.
Faith.
Dr. Maloma, I'm very sorry. Now, we can discuss the rest of the issues. This is the crux of the matter. Now, from where you raise the issue, you are responding to the committee. You are saying you don't claim to represent. You are not saying you are looking at how we are going to correct this. So that's a fundamental issue now. So whatever you say going forward, unless it addresses how you want to deal, that's really what we wanted to know. That's the first of the issues that we want to clear. I'm saying, therefore, when the Commissioner Govender raised the issue and the other members were concerned, it's because this takes a defensive posture that basically says we're fine as we are, we don't intend to represent everybody, we'll come to you, don't worry. And that's where the fundamental issue is that needs addressing. Proceed, but be aware that's really where our issues are.
Yeah, Thank you, Chair. I think the presentation is structured in such a way that it unpacks as we move to the next pages. Yeah. So in this page, we are defining how we are represented. And then we are saying as a committee, we comprise representatives from the major umbrella bodies and Christian organizations across South Africa. And some umbrella bodies declined nomination to participate in the committee. That must be noted. And what we mean by the Christian sector, we mean the categorization of the church in terms of mainline churches, which are represented in their millions by SACC, which the screen there is not showing, but it's SACC representing millions of Christians across the historic denominations. African Independent Churches represented by Council of African Independent Churches, Zion Christian Church, Nazareth Baptist Church, St. Agnes Zion Christian Church. They serve millions of Christians in this country. They are represented in this committee. Evangelical and Pentecostal traditions through the Evangelical Alliance of South Africa and Rima Bible Church, we bring evangelical and charismatic perspectives onto the committee. Faith-based advocacy, we also have moral regeneration movement included as a component of Section 22. The committee is made up of pastors and clergy, theologians and academics, administrators and church leaders, and lay leaders. We are your brothers and sisters from across the broad spectrum of the Christian faith. That's what we tell our audience. We are appointed by major umbrella bodies to serve the sector. We are appointed, we are nominated by umbrella bodies, appointed by CRL Rights Commission in terms of its mandate. Within the committee, within the committee, the members don't serve their respective organization. They serve the interests of the Christian faith in terms of our mandate. Now, in terms of our regulatory framework, Chair, we always strive to balance between freedom of religion and accountability, which is a major debate in our country. And the committee has considered that in its framework. And how do we balance freedom of religion and accountability? We define religious freedom in this way. And this is how we see ourselves. We are a committee that is voluntary in nature, and that we were volunteered by our umbrella bodies to come and participated. We are not instructed by a state agency or any other government institution to do this. We are voluntarily involved as Christian church leaders for the church, with the church, to be able to come up with an ethical code of conduct that will promote accountability within the sector. And by accountability, we mean not the state control. So the framework targets practitioner conduct and public safety, not religious doctrine or belief. Practicing protecting the vulnerable. So that's what we are about, because we are designed to prevent exploitation, financial abuse, gender-based violence within the sacred sector. And I must say, under financial abuse, Chair, the new one that is coming in, including illicit flows of money and money laundering that is now taking place within our space. And how do we balance that with accountability? This we do through inclusive national consultation, which we have done. We are a multi-phase provincial consultations that are taking place now to ensure that we get directly to the Christian community as represented on the ground. We have a broad stakeholder representation. The committee has engaged more than 25 umbrella bodies, including those that are in the report of portfolio committee who are fiercely opposed. They have been consulted, they have made submissions, and we have met with government departments that are relevant to our task of formulating this code of conduct. And we are committed to reconciliation, actively addressing mistrust through transparency and formal dialogue with dissenting religious groups, and clarifying the purpose. The framework is not a tool for ethical conduct. It is a tool for ethical conduct, is constitutionally grounded, is a mechanism to protect the vulnerable. The framework is not a state control or regulation of religion. It is not interference with doctrine or belief of anybody else. It's not a replacement for existing criminal laws. And the architecture of this framework, we see it as a house of accountability. The framework is based on 3 pillars, Chair. One, when we talk to our sector, we say we need to talk about internal governance, because before you even talk about ethical conduct, there are failures within the sector wherein the churches are operating without any form of governance whatsoever, any form of accountability, even in terms of financial segregation. And then the ethical conduct, which is a pillar number 2, is geared towards shielding and safeguarding the vulnerable in our space. And these 2 pillars are also founded on the foundation of pillar 3, which is a support for legal compliance. The reason why we have so many problems in our country is because many of us are not legally compliant with various laws of our country, while the government is being always shot at as being a failing government. But the church has failed to support the legal frameworks that are in place in our country. And this house is actually kept with a proposed Christian Practice Council for Ethics and Accountability, which other people want to interpret as state regulation, but is nothing else but a voluntary or a self-regulatory Christian Practice Council for Ethics and Accountability. This is a proactive oversight layer that issues the seal of good standing, and it will shield the congregants from those who are abusing the system. Now, looking at the boundary line between ethics and legality, we argue that the state represents legality, and then we need to cooperate with the state in terms of the criminal justice, the SARS, Department of Home Affairs, CIPC, and what are the functions of these state entities is to handle fraud, physical assault, immigration violations, and tax evasion enforced by the law. But this is where our framework comes in. In terms of our framework, we're looking at pastoral ethics, grievance mediation, internal safeguarding, and governance standards within ourselves. And the function of this framework is to fill the critical gap, handled voluntarily by independent religious councils, similar to medical, financial, and other bodies. And this is an untouchable zone that we want to proclaim to the committee today. In terms of scope, we're saying doctrine, divine calling, scripture interpretation, spiritual expressions is a no-go zone for this committee. And why so? Because constitutionally, the church and the religion is protected under Section 15 of the Constitution. So the state and the framework remain entirely out of this space, even as you, Chair, elaborated when we started. So establishing a voluntary self-regulatory framework is not a state-imposed regulation. We argue that what the framework is a voluntary self-regulatory framework, sector-led by Christians for Christians, a tool for accountability and ethical conduct, a mechanism to protect the vulnerable from exploitation. The framework is not state control or regulation of religion, state-imposed licensing or government oversight. That's not what it is. Interference with doctrine or belief, a replacement for existing criminal laws. So this is not a state control of religion. It is a proactive, voluntary initiative by Christian community to safeguard its integrity. That's what it is. The framework operationalizes existing state laws to protect human rights. So particularly focusing on the vulnerable or protection of the vulnerable, we aim to work together with the social development. We aim to work together with women, youth, and disabilities so that we can address issues of accessibility in churches, youth accountability, GBV prevention and reporting. We also plan to work with basic education to regulate school chaplaincies and safeguarding children in church-run schools. Human rights and oversight to ensure that we balance religious freedom with human rights audits. We also want to cooperate with gender equity to ensure that sexual misconduct provisions and there are gender audits that take place in our space. We also want to work with the public protector to enforce ethical boundaries regarding public funding to faith-based organizations. We also want to harmonize religious operations with state administration and labor standards. And those are, in terms of administration and finance, we're looking at SARS, we're looking at CIPC, we're looking at how we work with Home Affairs to ensure verification of good standing for foreign leaders and visa compliance for migrant churches. In terms of labor, health, and culture, we're looking at how do we formalize contracts.
Try and round up, Dr. Maloma, try and round up. There were more specific issues that we're interested in.
Let's go to the next slide.
15 minutes. We finished the 15 minutes that I allocated. I'll give you 5 more. Please close after that.
Yeah. Okay. Yeah. Chair, that's the consultation ecosystems. We have seen the Chapter 9 institutions. We have met with umbrella bodies, advocacy groups, and then we have met with government departments and regulation. Next slide. And then let me skip this slide as well. Next one. And then erecting the scaffolding, a whole of society consultation engine. Phase 1, as we indicated, we have met with all the umbrella bodies, those who are for and even against. We are busy with provincial consultations as we speak. We are going to Western Cape on the 18th to the 20th of August. And then at the end, we'll be able to synthesize and have a summit where we'll call back the leaders, call back our theologians and lawyers to look at the final document before we present it to CRL for the report to Porter. Next one. And then we want to argue this issue of inclusivity. We say inclusivity is determined by the breadth of the process, not just committee membership. We do not claim to have every voice on the committee. We claim to give every voice an opportunity to be heard. And this is what we are doing, and this is what we are capturing throughout our process. We cover African independent churches. We reach out to Pentecostal, charismatic, independent pastors, women, youth, survivors, foreign national congregations, opposing advocacy groups, mainline denominations, etc. You can move to the next one. And mapping the deficit. The CRL's mandate and intent is to facilitate a sector-led peer review system. Scope is ethical pastoral conduct and safeguarding. So the public backlash, maybe we need to comment about that. Yes, there's a litigation that is at High Court applied by South African Church Defenders. The same South African Church Defenders organized two marches we are aware of, Union Building and the one in Parliament. And Chair, we must also raise this issue that South African Church Defenders were established in August 2025. In 3 months, they organized 2 marches already, heavily funded by who, and the church leaders are asking and want to know who is behind the funding of South African Church Defenders. And because they seem to have actually raised many of the complaints towards the consultation. And the core fear is deep suspicion of state-imposed regulation of religion. And Chair, you have said that quite straight. You have clarified it. There's no basis, there's no reason for suspicion. So the point of disagreement is the suspicion that the process is masquerade for the state regulation of religion. And we want to say that is not really our experience. So myth versus reality, we're saying, yes, this is not a state regulation, it's a self-regulation. And I'll just pass because of the limited time that I have. Next slide. And those are provincial rollout strategies. We can pass that. And
you have 2 minutes.
Yeah. Chair, that is what we have achieved so far since we are established in October. We have managed to draft a framework. We have in our place, CRL has got that strategic plan, our consultation plan, and our consultation report for phase 1. And then we are busy. We have had successful KZN and Eastern Cape consultation were completed. So we continue now to Western Cape, and then we noted some of the things that has been said. These are the metrics you can see for yourself. The depth of breach so far, plus minus 500 inputs have been received over the last 2 provincial traction, and then 400 participation in KZN and Eastern Cape of religious leaders, church leaders, not religious, church leaders who have a serious following behind them. And you can pass that. And Chair, we do more with little, with less. We conduct our meetings virtually. We do target provincial visits. We partner for venues with churches wherever we go to cut the cost, and then churches are participating to assist. And then most of the activities that are done are self-funded by members because of the challenges that we have. And the strength that we have is the skills and knowledge of the sector that is found within the committee. And we pledge to the portfolio committee that will consult inclusively, will harmonize the processes, will build trust, and will deliver the report at the end of the process. And you can pass that. Or this one, yeah. So we are all about building a church worthy of public trust. So this process proves that absolute religious freedom and rigorous ethical accountability can coexist. Our singular goal remains a church that is faithful, accountable, and universally trusted. And Chair, we also make our own observation and recommendations in terms of your published recommendations. If you allow me, I could go through those because they are very important. Developing a code of
ngizozwa-ke uba ukuthi bathini udokotela uyavuma yini basondele.
Nkosi, please mute. Nkosi, please mute. Look, can you close this matter? I've got members wanting to come in.
Yeah, I'm closing now, Chair, with that our comments on the recommendations. As far as point A is concerned, yes, we say each religious sector will have to do its own code of conduct. In terms of reforming Section 22, say Section 22 Committee for Religious Sector must include representatives from ad hoc committees across all religions. That is a later one, the way we understand the usage of religion there. In terms of inclusivity, will ensure that everybody in the consultation process, all their voices are heard, including those with different views within the sector. And the issue of the CRL chair, I think the commission is dealing with that with the committee. And the Christian Sector Ad hoc Committee already incorporates portfolio committee's feedback in its consultation, and it makes output available to Parliament through CRL Commission. Today's engagement with the portfolio committee for us is a critical step in that alignment. The Christian Sector Ad hoc Committee intends to submit final consulted self-regulatory framework to the CRL Commission in May 2027 for submission to Parliament. Thank you, Chair.
Thank you very much. In short, you are basically saying you are not changing your committee to deal with the issue of representation. It's enough the way it is. You're going to consult people as you go along. And so that's what I'm hearing. Now, let me get the members. Do you want to start engaging? Do you want to, Honorable 𝐿𝐴𝐵𝐿𝐴?
Yes, please. I would like to start engaging. I would like to know, first of all, my comment on this presentation or report. Thank you for that. Everything that you've mentioned, that each church will, or each group will have to have their own code of conduct, the organizations that you will work with to erase corruption and money laundering and gender-based violence and all these things already exist. There's a whole set of legislation in this country. According to my opinion, and not only my opinion, according to everybody who have listened to this, will tell you that if churches and religious organizations have their own structure well organized, you don't have to have a legal framework. The legal framework of every citizen in this country is the existing laws. So if you discover that some pastor or dominee or religious leader is doing things that are not supposed to be done, it is the responsibility of that church to investigate and to lay the charges and to follow the rule of law. Because each church is supposed, or each religion group is supposed to have a code of conduct or the ethics code that is based in part of your religion. That's first of all. Then I would like to know, does all the other organizations, because you are representing, and maybe you won't be able to answer me, but the chair of the CRL chair, you said exactly, very clearly, that you are representing the Christian faith organizations and not all of them. But I would like to know, does other religious groups also have a subcommittee authorized by the CRL, funded by government, by the CRL, funded by a Chapter 9 institution, to do a legal framework for their organization? Because if not so, it is clearly that there's a discrepancy here, because only some people are represented and get support from government, because this is support from government. You move around as a commission on a budget provided by government. Now that in itself is government regulated. So to me, it's very clear that the framework of ethics that you are saying and is something that each church have to work out for themselves. And obviously, there can be support from government or from this oversight role from this committee. But the framework that you refer to is still not very clear to me. What is the content of the framework? Because you refer to the framework and then you say each code will have their own, each group will have their own code of conduct. Because if there's a code of conduct and there's legislation, what is the framework that you need? Chair, I am more confused than I've been before. Thank you.
Honourable Van Zyl.
Thank you, Chairperson. If we can maybe just look at the chat group, and I will read the last comment by, I think it's a Commissioner, Sylvia Peto, and it says, the CRL Section 22 committees are tabled at CRL plenary by chairpersons of Section 22s. But for the Section 22 Committee on Christians, no report has ever been tabled at plenary. So as commissioners, we have not seen a single report from the Section 22 Ad hoc Committee for Christian section or any other sector. This is the challenge raised by Commissioner Mantula earlier on the interpretation of the CRL Act Section 22. I think, Chairperson, this is very worrying coming from the commissioners, and I think we need some response on that. And then just a comment from myself, when I think it was Commissioner John Maluma, I think he's the chairperson of the Section 22 committee, he said that we've had very successful outreaches in both the Eastern Cape and KZN, but yet we've received emails to the contrary, and that can be provided to the chairperson. So I would like him to really comment on those as well, because it's completely contradictory to what is felt on the ground. Thank you, Chairperson.
Honourable Swart.
Thank you, Chairperson. Very briefly, I think the presentation goes to the heart of the concerns of the committee, and that is representativity. And if one has regard to the submissions that were made, it was not a case of part of organizations and churches choosing not to participate. They were, according to the submissions, intentionally excluded, and that is not dealt with. So I think the question of representativity, which you correctly raised, has still not been addressed. We are of the view, as many are in the committee, that the Section 22 is not correctly representative of the Christian sector, and it is a concern, with due respect to all those that are on the Section 22, when you have one church grouping, the Nazareth Baptist Church with 6 members, and you refer to the 𝐟𝐸𝐺 Church as a significant representative and TISA of the whole charismatic sectors. The question also arises when reference is made to the South African Council of Churches. A number of members of the South African Council of Churches have withdrawn their support of the Section 22 process. So I appreciate what is being done here, but I do want to just take issue with the greatest respect to Dr. John Maloma on representativity. I would then also like him to comment on the existing code of conduct that has been developed, that has been broadly accepted following the 6th Parliament's engagement, following the national consultation. There was a broad code of conduct, and whether that is, why has that not been incorporated in the process? Thank you for the time being, Chairperson. I'll leave my comments at that. Thank you so much.
Thank you very much, Dr. Maloma. You're going to respond, but I'm going to open up for other members to respond as well.
Yeah.
As you do the presentation, two concerns keep lingering in my mind. Firstly, yourself, the Commissioner, Governor, and some other commissioner, it seems you are saying to us, look, don't worry about people who are complaining that the committee is not representative. We can't accommodate everybody. We're fine now. We'll just go and talk to them. I'm putting it like that so that we can understand how it sounds as we listen. The second one is that the processes we are going through, you are showing a lot of success. We are having a lot of concerns. So we're not getting to a point where the process is getting aligned. Instead, your process would go on, and then people will still keep coming back to the portfolio committee. Whereas we need the committee to conduct itself in such a way that all the issues get to be resolved within that process. But if they are not, the committee won't stay away from dealing with the concerns that are coming. So now, if we try to hand over a process, but then the process is such that it keeps excluding or pushing back certain people, we are likely to have a challenge there. Now, there's another point that's been raised here, and I'd like those commissioners to say, what are you saying to us? Commissioner Peto and Mantulo, what is this issue on the comments that you've made? So let's come back to that, but let me get you to comment, and let's move it from there.
Thank you very much, Chair, and thanks to members for questions. Chair, what we mean by success, and specifically zooming into Eastern Cape, firstly, Eastern Cape, given its vast geographical space, we divided the region into the province into 4 regions, in which we targeted to have 2 sessions per day per region. And in Eastern Cape, in East London, I can't pronounce the new name now. East London, we had 2 sessions as planned. Tata, we had 2 sessions. Queenstown, we had 1 session because the majority of pastors came there for 2 in the first session, and there was no need. In fact, there was no one coming for the second session. In PE, specifically where the complaints are coming from, we scheduled 2 sessions, and we started 9:30. Usually the sessions last until 3 hours until 12:30. In PE, we were with one group from 9:30 until 2:15. The session 2 did not come in, and then we noted the complaints that were lodged to the mayor that we cancelled unilaterally 1 session, and that is not true. I even sent a voice note to SABC to clarify that point. In KZN, we had 4 days of consultation. Everybody attended. The Chair, there's one thing that we need to categorically mention. There's one voice that is opposing wherever we go, before we go, when we are there, and when we leave. It's church defenders. So they came in KZN, they protested outside after the first consultation. It was only 9 of them. They returned the following day and joined the consultations. These are all recorded. They are in a video, and then they will be published to the public later on when we finalize our report. And then as far as the member 𝐟𝐨𝐫𝐞𝐻 is concerned, honorable member, I wish to state that the church is a fragmented voice. Those of us who are pastors, theologians, practitioners, we recognize that we are a very fragmented voice. And at the moment, the process is aimed at coming up with a council that will be able to provide one voice for the whole sector. So if you say there are enough laws, just read the SIU report, recent one that Home Affairs published, and see the role of pastors in smuggling illegal pastors to come and practice in this country, because there's a gap. Anybody in this country can start a church without asking permission from anybody, without licensing, without anything, even without proper documents like passport and visa. So that is why we are having problems, and this process is aimed at doing exactly that. And in terms of Honorable Swart, though he's not a member of the portfolio committee, I know that he's a political party leader making presentation together with us. I'm not sure if that is fair for the portfolio committee process, but I need to say to Honorable Swart, in terms of representation, all the bodies that we have mentioned, umbrella bodies, they represent overwhelming majority of this country, including SACOF.
Dr. Maloma. Dr. Maloma. Look, we are politicians this side. You are not. Don't get tempted into that space, because I'm watching that people must focus on the issue and not use politics to deal with your situation. Now, I don't like your arguments. You can't pick on Honorable Swart and say he's a political party. All the members here are political party members. Now, I don't see why you want to go in that direction, because you are getting yourself misdirected. Now, you either respond to the issue or you don't respond to the issue, but your reference to a political party that's making submissions, you didn't come here to make submissions. You came here to respond. Now, whether he makes submissions or not, it's not your business. I'm the chairman of this meeting, and I will tell you, I addressed his issue at the beginning. Now, you don't agree with him, you can just say what your views are, but don't start creating a sense that you want to pick on a political fight here, because you will not be accepted. That will not be accepted. Now, I've had these political comments before, and when they do come, I deal harshly with them. So please stay away.
Your Vice Counsel accepted, Chair. Apologies. Chair, I wanted to say the complexity of the church can only be understood by those who are in practice. I'll make an example. The leader of SACOF, he's a leader of Rhema Bible and Family Churches. He is a leader of IFCC. He's a leader of SACOF. He is also a leader represented in SACC. Such is the complexity of the sector. So when we say representativity and the comfort that we have as a committee, that we represent almost the overwhelming majority of Christians in this country, and for us it's historic. It has never happened that we have a composition of umbrella bodies as they are composed in this Section 22. So it also comes to the point that you raised, Chair, about reconfiguration. We don't see where we are now if reconfiguration would assist, because what we are asking, and we are seeing it happening on the ground, when we go down to the provinces, pastors and church leaders are responding favorably. They are even pledging after every consultation that they will gather, and then they will be able to formulate submissions in writing. So the submissions are coming in. So from that point of view, we feel strongly that this process is on its right track, and there are a few people that will make noise. We are noting them, we know them, we are in the sector, but our major umbrella bodies with significant following in this country are behind this process. In fact, they endorsed it before we even started. That here and there are a few individuals who are not happy. We are engaging with them, and we engaged with them, and we continue to engage with those that wants to make a submission. So I think that's where we stand in terms of representation. For us, it's not membership in the committee, but it's your voice being heard in the process. Thank you, Chair. If there's other committee members that wants to add, they may add. Through you, Chair.
Well, No, thank you very much. I think the honorable members, you're going to have to look at that matter from the committee, from the submissions to the committee. We had noted that part of the noise in this issue arises from the concern on inclusivity and representation. And we raised that issue because we believe that it's a matter that needs to be looked into. What the Section 22 committee is saying is that no, forget about that there is no such a problem. So effectively, we're going to have to find a mechanism of how between us and the Section 22 and the Commission, we're going to have to deal with the question of representation as a dispute now. Because that means we are saying that we are listening to the concerns about inclusivity and representation. The committee is saying they have got that sorted, there's no such a problem. So maybe you are right, maybe the committee is wrong, but that means we're going to have to look at how that gets to be resolved as a dispute between us. Leave those who have raised the issues with us, because we wouldn't preside over a process where it's a tick box exercise. We have to see that there's substantial influence on the process that will resolve the tensions that keep arising at the level of the committee, of the portfolio committee. So you are effectively saying, and this, we raised it at the beginning, and we've been tracking that your view is that there is no such a problem between, within the sector. Everyone is fairly well represented, and there shouldn't be a complaint about it, which means this committee is the one that's got it wrong. Now, maybe we should accept that this committee has got it wrong, and face that reality ourselves, that how do we deal with a situation where we get informed that there's a problem that requires a correction of inclusivity and representation, and then we are actually informed by those in charge of that process that no, it's not the case. That I think is what the members must face. Let me get the 𝐬𝐮𝐬𝐫𝐤𝐿𝐿𝐻𝐻𝐻𝐻𝐻𝐻𝐻𝐻𝐻𝐻. You want to comment and then followed by 𝐬𝐮𝐬𝐻𝐻𝐻𝐻𝐻.
Yeah. Thank you very much, Dr. Chair of the Portfolio Committee.
Try and get closer to your mic. I think your voice is a bit too soft, so we may lose you.
Okay. Thank you very much. Am I audible?
You are, but you get closer to your mic, you'll be better.
Okay, thank you very much. I would like to unreservedly advise that it will be premature to hold the processes of Section 22 committee on the basis of dissenting views, and let alone the fact that it is from the minority. And international best practice in public participation does not say that when there are dissenting views that emerge during the consultation process, then you need to stop the process. It is expected that there will always be those that are opposed to the developments, but the right approach is that the process must be allowed to run its course until the end. And then the public participation practitioners need to document the outcome of the process, including all concerns raised, and make recommendations after having weighed inputs from all stakeholders. Then it becomes the responsibility of the authorities to evaluate the submission and decide whether a particular proposed approach or development is approved. Making decision in the middle of the process is not only premature, but is tantamount to the lack of understanding of the principles of consultation and standard practice. The second point is that I would like to humbly raise a concern pertaining to the manner in which issues of the CRL chair are being addressed in this forum. With due respect, I'm of the view that it is not procedurally correct to interrogate the chair about her conduct in a public sitting like this, as it borders on the line of humiliation. I would rather kindly advise that you subject her to your own internal processes, which once concluded, and you can then schedule a meeting with this forum to provide feedback. And I'm also not comfortable with the fact that there seems to be a lot of undue attention accorded to the minority parties who are aggrieved by the Section 22 committee processes, ignoring the voice of the majority in the Christian community. And lastly, Chair, the very same breath that you recommend that CRL Rights Commission must not interfere with the Section 22 committee is the same breath that we are asking Parliament not to interfere. I thank you.
Thank you, 𝐬𝐮𝐬𝐫𝐞.
Thank you, Honorable Chair. I will greet the members of the Portfolio Committee and also the CRL Commission and members of Section 22 Committee. Firstly, Honorable Chair, Dr. 𝐬𝐮𝐬𝐫𝐞, with all due respect, I think I'll seek your proper understanding of my submission, which actually triggered me to raise my hand. Firstly, I intended to raise a plea to you and also members of the Portfolio Committee present in terms of your directive or a ruling to say the Section 22 Committee approach and interpretation leaves you with an option to conclude that your committee have got it wrong. Then there will be a determination by yourselves in terms of how do you deal with the matter, and you categorizing it as a dispute. I seek your indulgence in that matter that you and your committee members, please do review that directive if you may, as I'm pleading to you. The reason why I say so, I'll reference your statement when you allowed Dr. Maloma to make a presentation after there was a suggestion. You will bear me a second. I think there was a suggestion that this report needs to be tabled in a different meeting, and Dr. Maloma shall make a presentation just highlighting in response to the questions that are on the table. So I'm basing my request on that to say this was not a forum for this report. I prefer to have a reservation, inverted commas. I'm tabling it as a member of Section 22 Committee and Deputy Chairperson of the Section 22 Committee, that I think your directive that you have just highlighted before any answers from Dr. Maloma is informed by the content or context of this report. In that score, I were to request that until such time, a proper ventilation of this report, adoption or admission of it is concluded procedurally, only then at least that directive be sustained. Having said that, I will expect perhaps that at the end of the day, the Honorable Chair will comment on my request. Can I be allowed to move just to cover responses on questions which are left hanging from the time the meeting started until Section 22 Committee was given an opportunity? If the Honorable Chair allows me to tackle those questions, I wish to start as follows. Firstly, I want to affirm the statement that was made by the chairperson of the CRL Commission to say that they have not been part of the meetings or the consultative process that has been embarked on by the Section 22 Committee. That covers KwaZulu-Natal, I think it started in Gauteng, KwaZulu-Natal, and the Eastern Cape. I wish to affirm that. Secondly, I need to comment on the Portfolio Committee's report and recommendations that has been presented today. I think the manner it has been presented and the presentation that was done by the CRL chairperson clearly makes it certain that there is a little bit of a green light in a sense that the report is positive. The recommendations tabled, even though there are some that needs to be unpacked through these discussions, but it shows a positive sign towards a successful mediation. As the chairperson has highlighted in the beginning, that these are matters which, in the Portfolio Committee's view, did not require investigation, but a successful conclusion on mediating them and finding each other. My third point moves to the issue of the Section 22 committee composition, which may require perhaps, as is termed by the recommendations, a transformed Section 22 to cover the issue of representation. I want to limit my comment on the Nazareth Baptist Church, an umbrella body which I'm coming from. I just wish to put it clear to the members, to the honorable members of the Portfolio Committee, that the Nazareth Baptist Church is grouped into 6 segments. Even though it's all called Nazareth Baptist Church, but in terms of its composition, each segment or grouping has got its own leader, and they operate independently. We also wish to put on record that out of the 6 groups, only 4 are participating. The 2 groups are not participating. So in that score, the concern of saying that there is 6 members of the Nazareth Baptist Church forming the constitution of Section 22 committee, I think it may be misplaced in a sense of a failure of comprehension as to how the Nazareth Baptist Church is composed. But that will elucidate it further should there be a requirement to do so. If I move further, what I also needed to cover in conclusion is the issue of the complaint, especially from the Eastern Cape. We cannot be defensive and state that maybe the complaint is not valid. My suggestion will be that perhaps before I make a suggestion, is that the circumstances which we were confronted with, especially for the cancellation of the second expected session, was more informed by the extended time that was given to the first session, plus the absence of those that were expected for the second session. Should there be a reason to say that there was an attendance after a resolution was taken that a second session will not sit? I see no need that we should have an issue with regards to that. If the Honorable Chairperson will take this thing back to mediation, whereby recommendations can be tabled in terms of how do we review the deficit or the shortfalls that may have cropped up from the Eastern Cape. I know that there are cost implications.
Let's round up.
Thank you. I know that there may be cost implications, but I see no difficulty that those that think that were not consulted adequately can be reconsidered in the second round. Thank you very much, Chairperson.
Thank you. Honorable Van Zyl.
Thank you, Chairperson. Just quickly on what Mr. 𝐬𝐿𝐫𝐿𝐫 had said about meaningful public participation and those with dissenting views from minorities, etc., etc. I find it very offensive. And I want maybe for us to just have him understand that courts have thrown out, and we have this on our committee as well, if meaningful public participation has not been done, things get referred back, like we have with the traditional Khoisan Leaders Bill at the moment. So meaningful public participation, even if it is from a minority and a dissenting view from your own, is very important. Then on his comments on saying that we as a committee must not engage with the chairperson of the CRL Commission in this way, and he finds it very humiliating, is that maybe, Chairperson, you should explain to him that we have an oversight responsibility as this committee over any Chapter 9 institution, and that, we will not go soft on some and hard on others. I think that's very important, that he must maybe understand that. Thank you, Chair.
Maybe just to limit the issue so we don't go very far, maybe then just so that we don't have to go back to the same issue. Look, the Honourable Member Van Zyl, you are correct. In the first instance, we did not raise grievances against the chairperson of the CRL Rights Commission and asked her to respond. I don't know how the member of the committee understood it. We never did. In fact, I even went to the extent of saying we will not be allowing a process foisted upon the committee to say there must be a response without a proper framework. Now, the only issues here that is the chairperson who said they stopped dealing with the issue of the Section 22 committee last year. And if there were any issues that were raised, there have not been any comments about those. And as then said, there have been things that were referred to that go beyond the date that she's talking about, which was the comment that related to the president. That was raised with us. And I said, I do not intend us to get onto these issues because we have the first phase of this process for us was to see if we can mediate the misunderstanding. We could have gone on and actually laid the whole grievance process and then started an investigation. And in our own consultation with the legal team, we agreed that there's a lot of misunderstanding. That's why I was saying to Commissioner, I think, that there's no misunderstanding between the committee and the commission. The misunderstanding is between the sector and the commission in regard to the Section 22 process. And the grievances were around that, and the complaints about the chairpersons were around that. The person who asked us to talk about what those grievances were was Honourable Mtolo at the beginning, and I highlighted that these are the groups of the issues, some on the commission, some on the chairperson, some on the Section 22. And we said we're not dealing with those issues today, we're dealing with the way forward. Now, so I think we need to be clear so we don't create confusion on the issues that we're dealing with. So I'm leaving the members of this committee to address the question that the member 𝐬𝐿𝐫𝐿𝐫 is saying, ignore the minority dissenting views, take the process through and then consider those at the end. Now, well, I don't know how the commission would deal with this, the committee deals with this issue. That's not how we're dealing with it. We have issues raised here with people going to court, with people writing, marching and going on, and we're saying we will address, we will listen to them. So that's the issue. And also, I'm not sure when the members were talking about minority parties, whether they're talking about political parties or whether they're talking about minorities in the religious sector. And I'm saying that because I did rule that we're not going to get anyone getting tempted to get political commentary on this matter, because that in this committee we deal with. We wouldn't want people to start, playing over that. We have an issue here. There's obviously an area where we're going to be clearly, in fact, we're clearly disagreeing with the committee now. So let's get back to the issue. Let's allow Honorable Swart, and then we'll get Mantula, then we'll get Dr. 𝐬𝐮𝐬𝐫𝐿, and let's get Stephen Swart, and then get Mtwala, and then we'll get the two commissioners after that. Let's proceed.
So firstly, I want to appreciate you coming in and supporting me as a member of Parliament, fully representative in Parliament and allowed to speak on this committee, and I fully appreciate your protection in that regard. What I do want to say is there's a very clear dispute between the committee's views and the views of the Section 22 when it comes to representativity. You've clearly ventilated it right from the beginning of this meeting. That has not been properly addressed, and to then say, even if, and to say this is a minority view in the broader church context, there's no evidence to support that. But even if it is a minority view, it is still a significant voice of very unhappy churches that are expressing outrage at what they are seeing. And Chairperson, the only way that you thought this could have been resolved was for the Section 22 committee to accept that there was a challenge with representativity and to address it, and not just say by going out to allow people and organizations to speak, they address it. That is a part of the public consultation. Our concern, your concern, is the representativity on the Section 22 that is the subject of a court case that seems to have been, from the word go, specific organizations were specifically excluded. Yes, there might have been some that chose not to participate, but many organizations on the correspondence they sent to us were specifically excluded. Chairperson, it seems there's a dispute, but we exercise an oversight. Let that not be misunderstood at all. A parliamentary and constitutional oversight. We are entitled to make very strong recommendations, and maybe it's the time to say, in view of the fact that we are of view that the Section 22 is not representative, we recommend that its process should be stopped or halted, pending the concerns that we have addressed, the fairness with the process as has been elucidated, the representativity, and of course, the issue of costs being incurred should this process be undone by the procedural issues that have been raised with this portfolio committee, as well as the court case. I think these are very important questions that we as members of Parliament should also ask about the funding and the process going forward. So Chairperson, from our perspective, we would suggest that the Section 22 process be halted until representativity has been addressed as you have recommended, Chairperson. But I strongly want to support you in your ventilation of this issue from the word go. Thank you, Chairperson.
Honorable Mtwala, thank you very much, Honorable Swart.
No, thanks very much, Chair. The electricity is bad, Chair, so that's why I'm putting my video. Honorable Chair, I think you just clarify my question when I first spoke.
Sir, I think you should cut off
my
your
concern
video.
was,
Cut off your video to improve your signal. Yeah.
okay. Am I audible now?
Better, yeah, much better. Proceed.
Okay. Okay, Chair, let me just clarify my first question when I first spoke. My question was about questions or concerns or complaints in totality. It was not specifically about the chairperson. I think the honourable member that raised the question in the form of flagging the complaints, the chairperson was Honorable Salt. So just want to clarify that. So why I actually raised that question is because I was having a problem with the collection here. So I couldn't open my other gadget. So that's why actually I need that clarity with regard to that. But it was in totality in terms of complaints that were raised. And then we clarified those questions, and then I responded positively after you clarified it. Chair, I think actually it is also important to raise the following. Understand that actually we don't actually encourage politics in our committee, which I really appreciate. But it is also a fact, Chair, that we need to note, or it need to be noted, that actually our constituencies, in terms of issues of interest, although we are political parties, are not the same. So I think it is important that actually that should be noted as well. So maybe that's why other members are raising concerns with regard to that. So as a committee, I think we should take note of that. So our political parties equally, but our interest and constituencies and issues of interest, although our political parties are not the same. So where issues are raised, we won't raise them equally because we don't have same interest. So why I'm raising this issue, Chair? Honorable members actually have a right to raise concerns. So if they feel that actually we have different interest on the matter as political parties, so hence the matter was raised. So I'm raising this issue because as a committee, we need to protect the interest of a committee in this matter. So I just wanted to sensitize ourselves as a committee by raising this issue. So I'm putting it to you, Chair, to be sensitive of our interest as political parties when you are actually sharing this meeting, so that all the members will feel free in engaging and be able as well to respond accordingly to us as political parties, or to us as this committee, or to us as members of parliament. So I think actually it is important that as members of parliament, we need to be sensitive of our issues of interest in our constituencies as well. Thank you, Chairperson.
Thank you very much, Honorable Mtolo. Firstly, let me agree with your first statement about when you raised this issue about grievances, you didn't single out the chairperson. I responded and said there are 3 groups of grievances. 1 on the committee, 2 on the commission, 3 on the chairperson. That's how I've put it. Now, we didn't ask for a response there. These complaints have been shared with the committee, with the commission before, and we never asked them to respond. In the first instance, I was the one who said we will not get anybody to respond to these issues. Our framework is not a framework of getting those concerns responded to. The committee sat down, discussed, and ultimately concluded that there is a mediation process before you start the investigation. And I said in this meeting, there will not be anyone requested to respond until we are clear what is it that we're asking them to respond to. The fact that there are statements in the report is not the same as when we've got an investigation of concerns for which a chairperson must now table a response. It's very different. That's what I was explaining. As to what is this that the member of the committee says is humiliating, I still haven't got that. In any case, let's come back to your point about the political party views. I think my issue here is that the committee members and the commission need to focus on the issue on the table and not try to politicize them in any way, because we have here, all of the members here are all political party members. But we're dealing with this issue as a committee. We're not dealing here with a party political contestation of views of what is happening. We have a commission, we have a committee decision, a committee report that is informed by the issues as they affect the various sectors of our society. Of course, political party members raise the issues as well, but the issues are not party political in nature. They are social issues involving the religious sector and the various communities who are concerned about how the matters of the religion are being handled. So my comment is that if we get derailed by comments that are creating a sense of party politicization of the debate, I will rule on that and I'll deal with it very strongly, because the issue is much bigger than party political leaders. Yes, there might be differences here and there. We're not there yet. We're dealing here with the broad issues which have been tabled to us. The people who brought these issues to us did so without telling us which party necessarily they belong to. And from where I sit, they could have belonged to almost all the parties. So that's not the issue right now. The issue is, how do we deal with the issue of the code of ethical conduct and the protection of congregants, and as well as making sure that there's no misunderstanding that whilst that is being developed, then there are efforts to regulate the church by the state. And then we have said, let's separate the processes clearly, so that at the end it must be clear that the issue of legislation is a matter that is separate from the issue of the question of developing the code of ethical conduct, which will be done by religious leaders. So that's where we are. Now, I'm going to ask the members of the commission and the committee to come back, because we need to move towards closing this. We thought that by now we would have closed this matter. Obviously, my view is we need to know where we've agreed, where we've got disagreement, so that we can see whether the approach that the committee wanted to use going forward can in fact be sustained. And that's why we're having these comments and we're opening up to those comments. So we'll start again with the Commissioner Mantula, go to Dr. 𝐼𝐨𝐫𝐿𝐿𝐿, then go to Oscar Madlala, and then come to 𝐬𝐮𝐬𝐜𝐫𝐢𝐛𝐬𝐿 at the end.
Thank you, Chairperson. I'll be very brief, just to touch on what was on the chart by Commissioner Peto, to just confirm what I think the Member of Parliament, Marina van Zyl, when she spoke about the reform section 22, to say that is the committee recommendation, that let's look at the compositions, the mandate, the terms of reference, which I think it is correct, Chair. But I think one ruling that you made, Chair, at some point was that we should allow section 22 to operate independently. And the issue was also raised by your member of committee to say there are 3 court cases pending, and we should be very careful in terms of awaiting those court cases in terms of the legitimacy and the validity of section 22 committee. So those are the points I wanted to flag, Chair, because I think we are here discussing the draft of this report in terms of modalities and operationalization of it. And I don't think we are doing bad, Chair. We can differ with views, but I think we have to always consider that all the questions that have been posed there, they are very critical for us to find each other once more to say the issue of the reform section 22, Chair, and the issue of the question that you raised under page 7 in terms of the misconduct, alleged misconduct. We should also look into those issues. We should not look at the report selectively because you have taken time to can consult with all parties involved. So we need to give the same energy back to this process again by finding the resolutions to these challenges, Chair. Thank you very much.
Dr. 𝐼𝐻𝐿𝐵𝐿𝐿𝐿.
Thank you very much, Chair. I just want to congratulate COGTA, CRL, and Section 22 as I see us converging to one point. We all agree on the code of conduct, and I think that is very progressive, including the people who are not on this meeting today. As we are going through the consultative processes, even if we're not done, there seems to be an agreement on that point. My last point to comment on is the inclusivity of the Section 22 in as far as participation is concerned. I think issues were raised previously on the issue of participation, and the Commission, I think, made some changes where even the voice of women was not included, and we all understand that the abuse in sacred spaces affects all genders, but mostly women. And we were brought up for that reason, representing South African women in Christ with women based in all regions who are mostly in the charismatic and the Pentecostal sector and mainline churches. So my contribution would be that I think we are finding each other. Maybe if we can understand who are the people who feel excluded, maybe that will assist us so that we can see if in the committee that is there a way that they are excluded? We establish that for a fact, and then maybe if we do establish that, then maybe discuss what needs to be done. That will just be my contribution to you, Chair, not running the meeting, but I'm just very happy that you are chairing this meeting very well, and we seem to be in principle agreeing on the gist and the crux of the matter. Thank you.
Thank you, Dr. 𝐼𝐻𝐿𝐵𝐿𝐿. Let's have Reverend Madlala.
Honorable Chair, thank you so much. I've been partially covered by Dr. Mhlongo Jones on the issue of inclusivity and representation. Chair, I want to bring to the attention of the leaders gathered here that we are dealing with a very complex subject. Insofar as we are the Christian sector, but even the Christian sector is so diverse. And it doesn't mean that every time we have such a subject, we'll always agree. So differences will always be there because we come from all walks of life. You know, Christians, once you talk about Christians, it's not just one body, but you talk to mainline churches, charismatic churches, African Independent, Orthodox, Protestant, Episcopal, and so forth. So you can imagine the level of complexity of the subject. On the other side, we are having a challenge of different narratives and public discourses. Now, I want to respond to or make a comment on what the Honorable Swartz was submitting, that let us hold the process. Chair, my submission is that ground has been covered already. it won't help the process to hold it at this moment. One launch has been done, resources have been used. We represent various umbrella bodies in this Section 22 committee. And I want to submit that what has been done is a way of, taking us forward as the nation in addressing all these challenges, including the spiritual transgressions and all the challenges that we know emanating from the findings. Now, all we need to do is that, as the doctor was saying now, that we can only improve the process. Those who feel excluded, let's try and delimit our debate, move from, talking about inclusivity, but identifying in detail that who else needs to be included so that we close the gap. We can improve and strengthen the entire process and make it more credible, inclusive, and even transparent, guided by the constitutional policies. Otherwise, my question will be, what about the work that has been done? What about the visitations consultations, as well as the engagements that have been done around the country? Thank you so much, Chair. I'll pause there for now.
Thank you very much. Let's have Makudu Khanyane and then 𝐬𝐮𝐬𝐫𝐞 thereafter. Please drop your hand as soon as you are done.
Thank you very much, Chair. I want to say,
try and get closer to your mic. You get to sound a bit soft.
Yeah, can you hear me, Chair?
If you keep it like that.
All right, thank you very much, Chair. I'm saying when you travel, there is passengers that you travel with, and those passengers has to get to be checked that they are the passengers that are right for this mission. And then on the other hand, when the flight is in the moon, you cannot put anyone into that flight. You must wait for the flight to arrive, and then if there is any concern, it's then that you'll be able to put those ones into that end. What I wanted to emphasize is that when we talk about the reform, we're talking about reforming the religious sector, not the Christian sector. Because when you reform all kinds of Christianity that comes into one, not to reform the established committee that already is established. The second point is that I want to talk about the minorities. Madam Chair, Van Zyl and Stephen Swart talked about it. In accounting, we talk about a materiality. If something is not material, we don't take cognizance of it. So those minority people, you are in a position to know who are those in minority because you've got the documents they've submitted to your parliament. And then lastly, let's not consider to have quantity. Let's have quality. So that's why we are saying every voice matters. But no, you are a portfolio committee, you have been chosen. You have been selected to participate as a portfolio committee. They cannot take the whole National Assembly to run what you are doing. They've selected you. So please give CRL the chance because they've established this thing. Look at the processes where when they finish, it's then that they will submit the report to Parliament. It's then that you can talk about your reform. And then lastly, I want to finish up with this scripture to say, "For I know the plans I have for you, declares the Lord, plans to prosper you and not to harm you, plans to give you hope and future." I thank you, Chair.
Thank you very much. I think just for information, 𝐬𝐿 we were there at some point with this commission, and we did make a point in the report. You will see there isn't a way this committee, portfolio committee, will ignore any concerns in your process until the end. There isn't a way we're going to do that. So just understand it. That's how we got involved. In the first instance, when things started, there were concerns raised and we started dealing with them. And there isn't a way we can just say you are a minority, just disregard you. If there's one person raising an issue, we want to first understand what is the issue. Is there a basis for it or not? And we are here because we believe that there was a reason on which to take the matters raised with us and address them. And we're in that process, and your view is we shouldn't be bothering. The two, you're raising the issue of materiality, the minority. Well, we're saying that's why we're differed with the process, and we will see that in our report. Let's get the chairperson, Ms. 𝐾𝐨𝐧'𝐭.
Thanks, Honorable Chairperson and honorable members. I would like to say, as you said, we are going towards the end. In light of the inputs from honorable members, and also we considered the report as the CRL Rights Commission, and the report I tabled earlier on was agreed to by all the commissioners. In light of that, we are willing to engage with the proposed forum to discuss the issue of strengthening the Section 22 ad hoc committees, including the one on Christians, if needs be. We are very much conscious of the fact that the charismatic churches are not there in terms of their umbrella organization. We raised this issue when we met with yourselves, that the IFCC, we told them that the door remains open, and we even asked that there could be a mediation to try and bring them back because they were part of the Section 22 ad hoc committee for Christians. So from where we stand, Honorable Chair, honorable members, we are willing and able to engage. Thank you, Honorable Chairperson.
Thank you very much. I think we must try and bring this meeting to a conclusion. And Honorable Mtolo, I see you have the hand up. And honorable members, any other comments so we can close?
Chairperson, I think as a committee, we won't be doing justice if actually we haven't actually made an attempt or to ask the following question. I ask Chairperson whether after having intervened or tried to resolve these problems or misunderstanding, is there any possibility actually for those who have opened cases or parties that have cases in court, we don't give they could actually withdraw their cases in court and allow this process to unfold if they have confidence in it. Maybe before you close, I raise this question. Thank you, Chairman.
Honorable Mtolo, it's been difficult to hear everything that you have said. before I repeat to the meeting, I'm going to ask you to call me again. Just your line is not good. Maybe your cell will have a better line. In the meantime, let's allow Mamura to come in and then Ndamase.
Chair, thank you so much. I'm just emphasizing what Dr. 𝐼𝐻𝐭 said, which might make life easier in terms of reforming Section 22. Maybe to identify, probably you have a data of those that feel excluded, so that our life can be very easy to see whether they're included or excluded, and also support what the chair is saying. Maybe CRL also to participate, to get involved with portfolio committee to discuss the issue of inclusivity. But we need to know who are those people that are excluded, because it looks like we are talking on the air of people being excluded, especially after we have done the umbrella bodies, and even those that have been mentioned, they were part of submissions at the consultations. So, and also, maybe somebody mentioned it earlier, the ad hoc committee, it cannot take everyone to do the work, because otherwise it's going to be maybe the cost, and it might not be possible. I think that's all what we are saying. Thank you.
The chairperson of the CRL Rights Commission says they are aware of groups that are not participating. The members of the Section 22 committee say they don't know who's not participating. I don't know how we land in that situation. Honorable Ndamase.
Thank you very much, Chair. Apologies again on the video. Listening to the response by the RCL Commission through the chairperson, and looking at the recommendations that we have made in the report, is that we must stick to the recommendations and be able to move forward. We may not be able, as this meeting, to deal with the actual specific, which is the technical process of saying who has been excluded, because the chairperson has articulated, and therefore it agrees with our recommendation. Thank you very much, Chair. I'm done, Chairperson.
Yes. True. Thank you very much, Honorable Ndamase. Okay. Now, let's get back to the committee recommendations. Please put back those recommendations, Secretariat. Please put back the recommendations on the slide on the screen. Thank you very much. Okay. So, thank you very much. We have been through a long discussion, and these were the recommendations. These were the recommendations adopted by the committee. And I want to go through them again so that we will then have a conclusion on the direction we're taking, so that the portfolio committee should, pursuant to Section 1813 of the Constitution of the Republic, 1996, assist and protect the CRL Rights Commission by providing a forum for discussion of matters set below, pursuant to ensuring the Commission effectively fulfills its constitutional functions. 1, in the development of a code of ethical conduct for and by religious sector. 2, a reformed Section 22 committee. 3, inclusivity and representation gaps or in the Section 22 committee, taking into cognizance the religious sector's diversity and guided by leaders from each of the various religious faiths. D, comments by the CRL Rights Commission chairperson and grievances submitted by religious leaders against her. E, align all processes and eliminate parallel approaches to realize synergy in the work done by both the CRL Rights Commission and the Portfolio Committee. And F, pursuant to the finalization of the Code of Ethical Conduct by religious sector, embark on a separate process to assess legislative support and support necessary for implementing it and address other gaps in the application of laws to protect congregants. Now, from where we sit, the committee received the response from the CRL Rights Commission. And in terms of that response, I'm just trying to find it. Okay, in terms of that response, we had the chairperson focused on the following issues. Firstly, welcoming the chance to engage, and Commission recognizing the Parliament's constitutional oversight role and values the ongoing engagement with the Portfolio Committee, and therefore submit the response to welcome the Portfolio Committee's report and to reaffirm the Commission's constitutional reaffirms the Commission's constitutional mandate on this matter, acknowledge genuine concerns, and welcomes the Parliament's oversight role, commit to improving communication, continue inclusive consultation, and shift the focus back to the original problem. Now, let me then say, from the point of view of the commission, of the committee, we would like that all the issues that have been dealt with here, that have been raised, be addressed. So, sorry, just move the slide back again. All right, sorry. Okay. All right. So this meeting was about making sure that the approach the committee takes is to help to resolve the misunderstanding between the committee, between the commission, as well as the members of the sector. So what we would like to see is that the process of developing the ethical code of conduct does proceed, and that the Section 22 process gets reformed, and that the issues raised in relation to inclusivity, taking into account the issues raised by the various religious leaders, gets addressed. Move up the slide, please. Now, in the response of the Commission, we believe that these issues, we have an understanding on these issues. What we sought to do was to get a sense of how these matters could be addressed by the Section 22 committee. As we speak, I don't believe we have had that. Rather, we have had comments to the fact that they can't represent everybody. But nevertheless, from the point of view of the committee, this is a matter that does need to be addressed. The issues that relate to the comments by CRL Rights Commission chairperson and the grievances submitted, we have said that those issues would remain with the committee, and we will not make any further comments on it until the committee has determined what other steps need to be taken in that regard. And this was mainly, as I said, on the basis that the legal team has particular advices on how such a matter should be dealt with. And that this discussion was also going to assist on E, which is to align the processes that will eliminate parallel approaches, so that there's synergy in the work that's being done. And that the last point is an issue that we need to underline so that everybody understands that we are not here about raising the legislative issues, but we will deal with that issue once the whole matter of the Code of Conduct has been addressed. Because in the discussion that we've had, there is an understanding with the CRL Rights Commission, which is the reason why we have actually said that the process of the development of the Code of Ethical Conduct, the Commission should not be running that process, and that the Commission also should not be participating in the discussions around those issues. Then it will actually reduce the issues and the grievances that have been raised in relation to the utterances. We need to make it quite public that we're going to be separating the processes in that way. However, I think it needs to be known from where we sit as the portfolio committee, we believe that the issue of inclusivity has to be addressed. We believe that the issue of reforming the committee has to be addressed. We believe that those issues will go a long way towards reducing public discomfort on the issues of the Section 22 committee. We would like to just caution that this approach of saying everything is done, we can't do anything about it, we cannot include everybody, we think we need to be cautioned against such an approach, because this issue will keep coming back to the committee if it is not addressed. So what we will now need, we would need a process that takes us to the point where we need to give a report back to all the various members of this sector, particularly those who have been involved, including those who have been in agreement with it and those who have been in disagreement with it, to indicate that the issues of inclusivity will be addressed, and to indicate that the process of the development of the Code of Ethical Conduct will continue, but it will be in the hands of religious leaders, and that the issues that relate to the state regulating religion is off the table and it's not part of what is being dealt with, and that issues that were raised with the portfolio committee, those grievances, including those that related to the matter of the comments of the chairperson, will be left in the hands of the committee, and that we will not have parallel processes. All of the processes will actually ultimately ensure that we assist as much as possible for religious leaders to deal with the issue that is being addressed. Ultimately, we're dealing with issues of human rights to prevent the violation of human rights in the religious setting, but also to make sure that the religious leaders take an active role in ensuring that there is accountability within the sector, and that the issue of legislation or legislative support in this process will be addressed once all of this has been dealt with. So there shouldn't be any debate about whether this matter on the table is about state regulating religion. But I do want to warn that some of the comments that we are hearing are not helpful. For example, there are those who make comments that suggest that we've done the process, we can't be told to go back on any issue. The process has gone the way it has gone. But I've had another member who said, well, there are concerns about how the consultative process is going. We are prepared to go listen to them and relook at that. Now, that's the attitude we would have expected in a process of this nature. Rather than anyone saying that, you show us who are excluded as a committee. The portfolio committee must show the Section 22, those who are saying they are excluded. It's not a constructive approach. There are religious leaders that were part of the whole discussion that need to be part of the process of dealing with creating this ethical code of conduct. And a lot of them were excluded when there was a misunderstanding about whether this is a state regulating the religion or not. There are obviously lots of inputs that need to be made into how this process should run. And some of the issues that were raised by the Honorable Swart would have to go into that process to say, okay, there are views, we have particular views about how this process should be going, that must go into the process. And the process must remain open so that it can allow people to make those kinds of inputs. I don't believe that inputs will only come from only the situation where people would have convened consultative meetings, but there would also be situations where people would want to send some submissions and therefore they must then be considered. We need an approach that allows people to feel confident that if they've made submissions, those will be considered. What the members of the committee wanted to deal with is to get a sense that the process that is being embarked upon is not a predetermined process by the Commission. Now, we're sufficiently assured by the Commission that the process will be allowed to move on. But what I have concerns about are the comments that are coming from the members of the Section 22 committee, because those comments are very much likely to reignite the kind of tension that we thought we were trying to douse. Now, if that happens, it basically pushes the process back, so that the portfolio committee must now again go into this and listen to what the concerns are. And the committee will not stop listening to the issues if people raise it, if the process does not allow a sense of inclusivity to be part of addressing some of the issues that people are raising. There will obviously be different views and different opinions. But if people feel that the processes are open enough to allow them to raise their concerns inside the process, then there shouldn't be a difficulty. But if there's a feeling that there would be some people who are actually being pushed out or being disregarded because they are said to be minorities, they will only be considered at the end of the process, then of course we don't agree. And that is when we'll have to start now dealing with the fact that we have indicated that this matter of inclusivity needs to be addressed, and it has not been addressed. If it's not been addressed, then we're going to have to come back to say, how do we deal with the process? So I think, honorable members of the Portfolio Committee, we would need the CRL Rights Commission as well as the Section 22 Committee to come back with a concrete proposal of how these matters will be addressed, because we will then be convening. We had actually set a date for religious leaders to be met with these matters so that we can deal with these issues. But we would need to get a concrete response now on how these matters will be addressed by through this process. Before we can do that, we will not be able to convene a meeting of all the religious leaders. And we think this idea that whilst we're trying to resolve this problem, the Portfolio Committee processes can be taken as peripheral, needs to really be re-looked at, so that we can close one aspect and allow one process to continue. But if we do not manage to do that, then it means that the Portfolio Committee is going to be dragged back to this matter. Of course, we will not retreat if we are dragged back because of public discontent on the matter. Honourable Van Zyl.
Thank you, Chairperson. I think at this stage, for us as the Democratic Alliance, we don't agree with the recommendations that's in the report that COCTA Committee is adopting today. We believe that there should be amendments made, like, pausing the existing Section 22 process, pending the court cases and all the processes that has failed. And then, an independent review and reconstitution of the Section 22 committee. There's a couple that we have jotted down, but we will not be in support of the current recommendations. Thank you, Chair. You are muted, Chair.
Thank you. I see there's a hand of Dr. Mhlongo. Is that a new hand or old hand?
It's a new hand, Chair. Thank you very much. I'll try my best to be short. I just wanted to make a submission to our Chair, COCTA Chairperson. There seems to be a lot of hostility, around this issue, and our nation is at a crossroads. My submission is that we really need to strive, and do our best to fight this division. Because when you look at the issues in principle, you realize people are in agreement. Maybe it's the way we are doing things. So if maybe the parliament, this is my submission, can make a strong voice, just like today it is said the chairperson must do her best to refrain from commenting. I'm submitting this to you, Chair, that maybe even those who are opposing should also be asked not to be hostile to the Section 22 committee and also to the Chair, because there's videos circulating almost daily, with
I think you're making a new resubmission. No, you can't proceed. You're making a new submission and you want to go and discuss a matter that I said we will not discuss. I have said we're not discussing the issues around the grievances and comments around the chairperson. I merely made reference because I wanted to indicate the process. Now you are wanting us to start addressing those issues. And I've said that those issues must be left in the hands of the committee. So if you want to go back to that, you will not proceed.
Thank you, Chair. I was just saying in the reports, because sometimes if it's one-sided, then it keeps going, becoming a circle. I withdraw. Thanks.
No, wait. Now, you must either say that this report is one-sided, don't make it speculative so that I know what you're saying. What is your point?
Okay, my point is on the side of the chair not commenting. The people also,
Which chair?
the chairperson of the commission not commenting on the statements in public and the processes of the whole process of the discussions that are going on. So my submission was that because there's a lot of hostility where there are videos and cartoons, I think the issue must be also on those who are doing those videos. It must be discouraged. The parliament must come up with a balanced recommendation to both sides, or rather a directive. I'm not sure if I'm making myself clear.
You are not, because I've said to you that these submissions were made to the committee, and there was a request for the committee to investigate. And the legal team has said to us, there's a process of how you investigate such matters. In the event you are dealing with a misunderstanding, you need to clear that, mediate through that first, and deal with it. And in the process of doing so, we will then determine whether you want to take all of these these grievances for investigation. There's a process of how that gets done. Now, we have not reached that point. We're at a point where we wanted to see if this misunderstanding can be so mediated as to allow the process of the Code of Ethical Conduct to be concluded without much acrimony. Honorable Mtolo raised the question of whether this matter of the commission of the court can in fact be, those members in court could actually be asked to withhold or withdraw the matter from court. Honorable Van Zyl is making reference to the matters in court. Now, these matters were in court when we started as a committee, and we did say that the parliament is not itself in court. And I've said earlier when we were dealing with this matter that it is actually possible to get the matter resolved without going to court if we could get the right attitudes amongst the members involved. And those attitudes relate to whether, in fact, everyone can be brought into this process so that they do not feel that this process would end up with a state regulating religion under some kind of disguise. Now, the proposal that the committee has made in terms of how we take the processes forward was meant to open up the space for that. But from what I'm now hearing, there are members, starting from Dr. Maloma, and I'd heard from another commissioner earlier, and I hear now from Mr. 𝐬𝐮𝐬𝐫𝐢𝐛𝐬𝐜, who are saying that the process has gone on and those who were not involved may as well just be considered at the end. We can't represent everybody. In other words, there's no inclination towards solving the problem of inclusivity. Now, if you cannot deal with that issue, then I said on that basis, it means we are getting to a point where there is a deadlock then. We expect as the portfolio committee that the inclusivity will be addressed. We are then being informed that the portfolio committee cannot interfere and talk about inclusivity because that's already covered. And that's the problem. But I'm saying when we move from here, we needed the committee, because the chairperson and the commission had said that they understand the process, they are actually prepared to work together to solve this issue. Now, my point then was we need the commission to come back and show us how all of these issues will be addressed as we move on. So before we go to the next meeting, we need them to come back to this committee to say how we're going to deal with the issue of reforming, how we're going to deal with the issue of inclusivity, and how are we going to be dealing with the process of the code of ethics of those who felt there were issues that made them go to court. If we are able to address those issues, then the process can proceed without any problem. And I'm only raising that issue because when I said, and when the Honorable Member Lapus Kakhne said that presentation by the Section 22 is an entirely new process that needs its own time. And I said, okay, we will allow you to go on. But what I found to be a problem and what is missing is that it does not address the issues. Instead, it's arguing. In fact, Dr. Maloma was going on to say that they are wanting to debate the issue of inclusivity. Now, if you want to debate the issue of inclusivity, then of course that means we are not going to make any step forward. Now, unfortunately, it's getting addressed. It's getting debated by people who are actually supposed to be implementing rather than determining whether there is an issue of inclusivity. Now, let me just hold it at that, Honorable Swart, and then I want to come back to Van Zyl.
Chair, thank you. I also just wanted to indicate that in view of the fact that we had made a submission, which you very kindly said will be engaged on an ongoing basis, that we would also need to reserve our rights on the recommendations here, given the fact that we made a number of recommendations to improve the recommendations that are set out in the draft report. I just wanted that for record purposes from the ACDP's perspective. Thank you, Chairperson. May I also just say that given the fact that we are dealing with the religious sector and the Christian sector, that maybe we need to, as you started, continue a process of encouraging all participants to pray, because we know that blessed be the peacemakers, so that there will be peaceful resolution of the different issues that we are faced with. Thank you for allowing me that short input, Chairperson.
Okay, can I just get Honorable Van Zyl? Let me just get your last submission again.
Thank you, Chairperson. If you have 10 minutes, I can read you the whole thing, but I don't think this committee will continue with that. But I, again, would just like to say that the Democratic Alliance is not happy with the recommendations as set out in the report. We believe that this process should be halted, the Section 22 process, because there's quite a lot of issues with that, and also that bodies should maybe be established to investigate the chairperson's conduct. There is too many things up in the air at the moment. So unfortunately, we will not be agreeing to the recommendations as set out today. Thank you.
All right. Thank you very much. Let's note that. Let me say to any members, anyone who wants to make any comments before we close the issue then? All right. Let's note those concerns, and I'll have time to have a look at all the issues that you're raising. But nevertheless, we would need the Commission to come back. Let me say, let's give it a week. We'll have to rearrange. Let's give it a week to get the submission on how the issues raised here would then be implemented. Then at that point, we will then consider all the points that are being raised by the different members, and then we'll close the issue there, because what we initially thought we would be able to do is that there would be so much of a straightforward agreement that we can actually move to meet with the religious leaders and table a way forward. But in the absence of that, let us give it a week. We'll come back, but we will need the Commission now to be specific on the issues that have been raised here. so that we can see how the matter can be taken forward. If not, we will then be asking all the members to make a view on some of those submissions that are coming late in terms of the reservations of the different parties that are wanting to table. So at this point, let me say that the next meeting we will have will be considering a response from the Commission on implementation of all of this. In other words, where the Commission, through its processes, believe that the issue of inclusivity is no longer getting to be discussed, the reforming of the committee is not getting discussed. All of those issues, let's be very direct, then this committee will then come to the conclusion. Thank you very much. And let me then say, I want to thank you all for the time you have spent and all the submissions, your comments, your participation on this matter. Honorable members, we will excuse all the members of the Commission, the Section 22 Committee, and all those who are associated with that process will be excused. And I need us to take a short break so that we can then relook at our next agenda as the members of the Portfolio Committee. Should we say, give it about 20 minutes? We'll come back after. Sorry, is that a new hand, Mr. Swart?
Okay, I just asked to be excused and thank you for allowing my participation this morning. Thank you, Chairperson.
You're welcome. So can we take a 20 minutes break and come back? Thank you very much. Meeting adjourned. And thanks to the members of the CRL Commission and Section 22 Committee. You will be excused. You don't need to be coming back after the discussion, after the break. Thank you very much.
Recording stopped.
Like 20 minutes.
Just quickly checking on the chairperson. Thank you.
Honourable members, my apology for this delay.
Recording in progress.
Could we resume? See, all the members are here. May I just request that the members share their submissions they wanted us to look at, Honorable Van Zyl, yes, if you could share those submissions.
Will do, Chair.
Yes, not now. I'm talking about so that we could look at them in preparation for the next meeting. Can we move to the next item? Here we just need to formally adopt the reports from the previous oversight engagements. We have had a look at the report. Members can guide, but it's really more to say this is the report, and therefore can get the members to adopt the report. Yes, Honorable Van Zyl.
Thank you, Chairperson. I have quite a lot of concerns regarding both reports, and I'll just take us through the Eastern Cape one just briefly by pointing out three issues, and it's across the board on both reports. It's exactly the same. I did ask earlier this week that I would like the raw data. Now, you'd remember, if we can maybe go to page 13 as an example, under summary, I'll give you an opportunity to get to page 13. Under the summary. Okay, Chair, well, while that is happening, I can just read it. It says, the provincial executive to furnish the promised report on the overseas strips. I think this was regarding Sundays-River Valley Municipality. Further details around provincial government strategy around disclaim adverse, blah, blah. And it goes on to say that, there will be reports that will come. And similarly, if you had to look at page 47, and I would just like to read that also, under the summary, it says, all requested reports to be submitted within 2 weeks of the oversight engagement date. And there's some of them that are even saying that within 7 days, we need to receive input from the municipalities. Now, Chairperson, I can be corrected if I'm wrong, but nothing from the provincial government, 𝐶𝐽CTA department has been forthcoming. There's no raw data from the municipalities that has been forthcoming in either the KwaZulu-Natal oversight or the Eastern Cape oversight. So for me, it seems like we are having these pointless trips to go to these communities, to go to these municipalities, to ask them for the information, to interrogate them, to see how best their problems can be addressed and how we can have effective oversight. And this is exactly the problem that we have. This is nearly a year ago. I know because I'm from the Eastern Cape and I've been waiting for these documents to be coming for some of these municipalities. And the deadline was in December of 2025 and it was moved to January of 2026. It's almost a year later and no information has come from the municipalities. I don't know if there's been any follow-ups. There is no consequence management. There is no accountability and there's no, I would not like to say, but there's no hope. So, Chairperson, for me, these are just minutes from the oversights that we had, the engagements that we had with the municipalities. And I would like to know what is going to be done. What consequence management will there be on the provincial government not issuing us with reports, with the municipalities not issuing us with reports? For now, Chairperson, I would leave it at that. Thank you.
No, thank you very much, Honorable Van Zyl. Actually, we discussed this issue in a kind of passing, and we've never really faced it in the way that it really is. There are a few things here. Let me start with the simpler one, which through this process, we need to agree on how to deal with it. The first one is, if we do a visit and we do a report and we need to somehow adopt the report and say, well, this is the report. So this is what this exercise is supposed to be. So this tend to get overloaded, overtaken because of work overload, and they delay, and then they can't be scheduled. There's this agent and so on and so on. And sometimes the work we do ends up making this getting delayed, just the adoption part, or the conclusion, or the completion of the report. And therefore it keeps getting dragged and it delays and delays. That tends to also have a knock-on effect on the pressure with which you can push for the municipalities to submit. Now, there is no doubt that when we need to get this report, the reports don't need even a reminder on our side. The deadlines are known as we part, that they're supposed to do this within that period. So maybe I think we need to just have a kind of guide on how we could then manage this thing, because to get consistent reminders on this, you need this report kind of out there to be acted upon on a continuous basis. So that's the one issue. How do we deal with it when we get pressured with time and some of the things begin to delay, as it were? That's why, for example, I'm sitting here, we're not talking about visiting another province, because just to chew the few that we've already beaten on is proving to be quite a challenge. Then the next question is, okay, now, as you rightly pointed out, they have not given us this report. Maybe we should talk about what do we do with that. Whether they have reminders or not is one issue, because the question of having had deadlines on their side is a matter there. So what actions do we believe need to be taken when we've got a situation like that? In this case, for example, we should be at a point where we are saying, thank you, where we are saying, okay, they have not acted on this. If we write the letter now and say to them, we want you to explain why we haven't done this, and by which, by which date we should be getting this, and all of that. What other action should we then be taking on them? I think let's open it up, because it's one area here where I think on the one side, the province or the municipalities have not responded. On the other side, we've also got a kind of overload here that's delaying things on our side. But maybe, are there things that we should be doing differently or doing better ourselves here, so that we can then manage the situation so it doesn't come to this point. So let me open it up, and I think members can just give us a guide. What your view? What do you think should be done? What do you think should be happening? Let's get members to just comment and see whether we can find a way. We've been fighting with the Eastern Cape for a while over a few municipalities that we were actually concentrating on. And that took away time to even focus on others. How do we deal with such situations? I think the members, as members, we need to get to find an approach that can refine our management of this whole thing. Let me open it up to the members. As we sit here, Shireen, I'm assuming that we don't have any single report from the Eastern Cape based on this particular report. Is that the case?
No report was submitted by the Eastern Cape on
Just
the
say
matter.
that again. Sorry, just say that again.
Sorry, Chairperson. No report was submitted by either the municipality or the province stemming from this oversight.
Okay. And they've not been given any reminders?
Sorry, Chairperson. No, we haven't submitted the reminders to them.
To them. Okay, Honorable Mtolo.
Yes, Chair. Maybe I'll agree with Honorable Van Zyl. Chair, just for information, I was in the Eastern Cape for a constituency period. I was at Ngubaya Chamber and AP Kuma. Situation is very bad there. So I'm going to compile a report for this committee to see. But maybe you need to change the strategy in terms of how we deal with these reports and follow-ups after these meetings, oversight meetings. Because, Chair, if we don't do that, I'm afraid it will be viewed as a waste of time and waste of parliamentary resources. So if we as a committee, we don't change the strategy in terms of accountability, maybe this thing of accountability will need to be looked into very, very carefully because municipalities, when it comes to responding after oversights, they don't take it seriously. Maybe we should need a strategy in terms of putting more effort, actually exercising more authority over them, because really they don't take us seriously. As Sharine has just indicated that she sent them a reminder and they never responded. So I agree fully with Honorable Van Zyl on this matter. Thank you, Chair.
Thank you. Can I have 𝐬𝐿𝐫𝐠𝐞𝐿?
Thank you, Chair. Yes, I also just want to come in here on the consequence management. I think the fact that when we request certain information or reports as other confirmation or as more information, and that is being ignored, it is the same way that these municipalities ignoring whatever is being written to them, either by the provinces and or the AG or whoever. Because for us as an oversight, it's good to say we are doing what we're doing, but if we don't get results out of that, we also have to address that in a way, because we will go on and on meeting, and we will go in the circle of meeting and waiting for information and meeting and waiting for information. We are already in 2026 and we're still busy with 2024's Auditor General report. The next process is already on the go, and we haven't touched on that. So, yeah, I think as a committee, we have to say we didn't receive the information and who is responsible to check up on these municipalities for not doing so. I would say the first stop from my point of view is the provincial MECs. They have to do the Section 155 support, and the municipalities have to give feedback to them. So, Chair, I would really recommend that in our processes, that is part of oversight, not to ignore the fact that they ignore the oversight mechanisms that there are, because that is in many cases what is happening. Thank you.
Thank you very much. Honorable Van Zyl.
Thank you, Chairperson. Just upon sort of listening to what has been said by Honorable Mtolo and 𝐬𝐿𝐫𝐠𝐞𝐿, I think, you know, summoning the MEC or COCTA would, in the Eastern Cape and the KZN, would possibly be the first stop, as the Honorable 𝐬𝐿𝐫𝐠𝐞𝐿 said. But I think I would actually go further than that and also refer the matter to the Speaker of Parliament, because, you know, these persistent sort of refusals or arrogance to cooperate with Parliament can amount to contempt of Parliament. And I think we should make examples of the provinces as well as the municipalities that is not taking their jobs seriously, because at the end of the day, this is where service delivery lies, and this is why we are in the state that we are in, is because there's sort of a feeling that, you know, they are untouchable and they can do what they want. Thanks, Chair.
No, thanks, colleagues. Let me start by saying, I think what will help, firstly, Sherin and your team, that you do not wait for the formal adoption of the report for any action to be taken on it, because this, as we have seen, can take a bit of a while. You need to have a kind of monthly kind of checklist that basically says what did we ask for from the Eastern Cape and when is it due, and you put it in a kind of monthly review calendar that tells us by last week we should have got a report from 𝐦𝐨𝐫𝐸𝐻𝐵. 2 weeks later we should have got something from 𝐬𝐻𝐴. By such and such a time we should have got something from OR Tambo, and enter it in such a way that you've got a master list, I don't know what you would call it, a checklist that will be at the end of the month. We should have got reports from these particular municipalities, or we should have got from this province, in which case you will then send those even if the report has not been adopted, because the decision doesn't change by the time at which the report is adopted. I think let's have that, and maybe something that you can submit for the noting of the committee that says, this month we're expecting reports from such and such municipalities, and then reminders were sent to them, have the reports been received. You need something like that, because then we don't have to wait and want to discuss an issue that is 6 months, 8 months behind, when in fact we should be able to say, this is what reminders we have sent. Then if the members are saying, take the matter to the Speaker, you take the matter to the Speaker with recorded reminders. You recall that when we were dealing with Nelson Mandela, it became an issue as to by when were the reminders sent and by how long late after the reminders were expected to have been responded to, did they respond? Then you can tighten the issue that way. I think that must be the approach which we must take. Then you then report to the committee at the end of like a month. This month, these were the reports that we were supposed to have received, that they haven't been received. Even if you can do it in 2 months, because the cycle of the work may be even longer. So in the past 2 months, we were supposed to have received these reports. We have sent reminders. There is no response. And then we are able to then to deal with it. But you submit it as a noting for the committee. Every time we look at the meeting once a month, we look at a meeting where we look at the process, the program. Then we must then say which reports have been received, which ones were expected, and who is not responding. Then we do it like that. I think then we can go that in that particular route. But in this case here, I would propose that we write to the MEC and ask them, we were expecting these reports, we have not received them. Have they received them? If they have not, what have they done to ensure that these reports are prepared? That's the MEC. And we need to do a similar letter to the portfolio committee. Look, we have been expecting these reports that should have also served with them. Have they seen these reports? If not, have they taken any action to make sure that these reports are received? Then we have got the line of accountability that the members are talking about, actually all in place. When you decide to take the next step, you have already got enough background proof of the fact that they have not responded as expected. I think if we take that approach, it would help us to solve the issues here. So for this one, we need to send a message, a letter to the MECs, maybe even to the Speaker of the Eastern Cape and the different provinces, to say, this is what we expected, we have not received any of it, have they acted on it, can they give us a report if they've already got, and then we do the same to the same municipalities. We expected these reports by this time, we have not received them, and we need them to submit these reports. I think we need that kind of tight approach. Could we agree on that approach, honourable members?
No, agreed, Chairperson.
Thank you. Thank you. So what suggestions do you make of this?
And some of the smaller townships also.
Hello, I think somebody needs to mute there. Yes. So my I think that approach, if we standardize it as a matter of noting for the committee at the end of its meeting, as part of way forward, let's get it structured there, Sherin, so that we don't have to remind each other about it again. Can you follow, Sherin?
Yes, Chairperson. Thank you.
Okay. Then we are going to do reminders for these municipalities and the provincial government and in fact, we need to also write a letter that goes to the Speaker as well. Then we can deal with all of it. Then, members, what do you suggest? Yes, Fansel?
Thank you, Chairperson. In anticipation of the end of your sentence, is that, you know, these, and I mean, a lot of effort has gone into this. I can really understand that Andile has probably listened to hours and hours of footage to try and do essentially what are minutes. These are minutes. And I mean, this report is 149 pages and the other one just as long. And for me, Chairperson, you know, the municipalities come there and we know that they lie. That is why we ask for the reports. So these at this stage read like minutes of what had transpired in those meetings, and we would essentially not be adopting a report, but minutes. So I would suggest that we hold off until we get the information from the municipalities, because these are essentially only minutes. Thanks, Chair.
I don't know. I think, can't we do it differently? You see, we do need a record of the committee as to what happened. Then we could then, if this is accurate report of what happened, then we need to adopt it and then set up a process that says we would then need these issues to be submitted in the next meeting with all the reports that are needed. Then we are looking at the analysis of the reports subsequent to the fact that we were there, because this is basically a record of the fact that we did meet with them and we did say certain things to them, and this is as accurate as we are going to be using it as a guide as we move forward. I still think that a way of adoption would be important, and then we can then set up the next process in place. Yes, Fansel?
Thank you, Chairperson. You know, these get tabled to Parliament and we debate in Parliament on these oversight reports. So in actual fact, we won't be debating on factual evidence. We will be debating on minutes. So that is just my parting 2 cents on that. Thank you.
All right, what do the members think? Because effectively, we did have a meeting, and this is a record of what we did, what we said and did when we were there. So it's a record of what we did already, what visit we had and what conversation we had. This is the record. Then going forward, as to in terms of whether we were able to confirm that these things were like that, it's a separate exercise of once they've submitted, we can then say, but you told us this and what we're finding is that. 𝐿𝐵𝐿𝐿𝐿𝐿𝐿
Person, yes, we have to have a report, and when people are appearing before us, they give us some information, we ask questions. But then very often we ask for extra information or some reports to confirm what we've heard. So in the body of the report, we refer to the conversation, to the discussions and the presentations. But when it comes to conclusions or recommendations, the conclusions have to be drawn and say, and we don't have a report before, yeah, we have to say, out of what we heard, this is what the conclusion, but we requested the following things to confirm. And because if we don't get those things, and this is the tracing document that I am talking about for many months now, if we have that in a report, it's very easy to pick up and say we haven't received this. So when we debate, we can say, this is what we heard, but it's now 3 months later or 6 months later, we haven't received this report. So we are not sure that this is the correct information or that we can believe what we have heard. Actually, this is why we are doing the oversight. So if we don't get these reports, we have to have a space in our report that's going to Parliament to say we didn't receive these documents in time. Because that in per se is giving a feedback without writing a next letter to say we didn't receive it. I don't know if you understand what I mean.
Yeah, maybe the members can guide. Yeah, maybe members can guide. Let's take an example now. If we decide to go to a municipality on an oversight visit, aren't we obliged to report that even though the processes may have been incomplete due to the fact that there was outstanding information, but insofar as what we did when we were there, everything has been on record. Then after, when we find that there's new information and so on, let's take the case of Nelson Mandela. Now, Nelson Mandela, we had a discussion with them up to this point. The discussion with them could have been accurate up to that time. And then we then go into the subsequent meetings, 3 of them. And when we're done with the conclusion of those meetings, we now have a report of the further engagement with Nelson Mandela. It's no longer the same as what we did when we met them first time. It's now on the basis of the subsequent developments that have happened since we met them. So that then has to be adopted as part of a process following on that. I'm not sure it will not end up with a situation where a lot of reports will remain hanging because there are certain things that are not concluded. I'm not, for example, sure that the amount of information we'll need will always be adequate at some point. I think there'll always be ongoing lacking information that we'll need. But other things could have been closed, but others could have still been left hanging. So I think we must think carefully about how do we dispose of that. Because we'll have a lot of reports that have got no status. They can't be confirmed as a record of our interaction. They can't be confirmed as concluded work in the particular municipality. But then what do you do with them? Do you just have a report that stays there? Yes, it's a record, but it's not adopted, so it cannot be used reliably as a basis on which you can debate or argue or take matters forward. I think it's a procedural matter for me. But let's take the last 2 comments and close. Yes, Ndamas?
Thank you very much, Chair. As far as the activity is concerned, in relation to the engagement we had with the 2 provinces, I would argue strongly that we must adopt these reports as our report so that we can be able to make a reference to them as our own report. What is outstanding is still we have articulated it in the meeting. What is outstanding, and there are letters that are still going to be written, despite the fact that those letters are overdue in relation to the information that was required. Assume, Chair, we were sitting this meeting 2 months after going to Eastern Cape, which was still within the period that we had articulated in terms of the update on the decisions that we took when we were there. We're still going to adopt the report. My view is that let's adopt the report and becomes our own document as a committee. Thank you very much, Chair.
𝐿𝐵𝐿𝐿𝐵𝐿𝐵𝐿
Chair, yes, I understand what you're saying. First of all, I just want to start out and say, yes, we have to have a report on what we're doing, but we are not the people who are being scrutinized for oversight. We are doing oversight over the municipalities. So the fact that we are going on oversight and say we are going to meet there and we get a presentation is our report. If we have the meeting, like let us take the Nelson Mandela Bay, the first meeting, we have to report on what has been happened in the meeting, and then with our conclusions and our recommendations. Our recommendations are normally the things that we further request. We need this, we need that, we need it, and we have to do it with a date. Now, the fact that we don't, we have to put the dates in there, and out of what we got the information, we have conclusions. It's not everything that we're going to get is not going to be handled on. But if we are going to only engage with them within the next 2 or 3 months, that should be a separate report. We can't wait for 2 or 3 months. If we have a meeting now and we know we're going to have follow-up meeting with them in a month's time or 2 months' time, then that meeting is a separate meeting. Now, before we have that meeting, we have to have the reports that we requested in the first meeting. And if we have an addendum to our reports, like we've many times proposed and say, give us a tracking device or a record and say, like we've done, it's been done now in the minutes. This is the report. Attach the report, or just say these are the things that you have to submit to us by that date. So it's very easy for the Secretariat to check on and say, these things were requested by the 20th of August. We received this, we didn't receive this. We don't have to go into 100 meetings on why they didn't receive it. Just report and say to the Minister or the MEC and say, the municipalities are not sending us these reports. We can't continue with what we're doing. Rather than to try and keep on getting the information from them, let them explain why they don't give the information, because that's a separate thing. What I'm trying to say, if we keep on doing what we're doing, we're also in the process of not making sure that there are consequences. The consequences would be, if they don't give the reports, the follow-up report should reflect that there is uncertainty about this because they didn't do what they committed to do. They didn't submit the report. They're late. So there's a lack of administrative either cooperation or ability, or what that case would be. Call it for what it is. Otherwise, it is what Honorable Namasi said, is we're going to wait for weeks to take action, and in the end, no action is going to take place.
Okay, no thanks. Why don't we then adopt the report with the concerns that there are a number of reports requested from these municipalities and province that have not been submitted. And that's our qualification, but this report is a reflection of what we had, our engagement, but we have a rider now that says we are noting that all the reports that were expected were not submitted on time. Then we take the next process now. Now, I do want us to be direct now. What would we want to do as a matter of consequence management in this regard? I think the issue of raising the issue with the Speaker, the Premier, and the MECs, and ask them what action have been taken becomes a very important issue. What else should we then be doing? So I've got two issues now. Can we adopt and put a rider that the committee notes with serious concern that a lot of the reports that were expected were not actually received, and that as a result, these are the steps we're going to take. Firstly, make sure we've got a tight tracking system. Secondly, we are going to raise the objection to the Premier, MECs, and the Speaker, and then as well as the committees to actually give us, to explain to us what they have done to get these reports and why these reports have not been received. Then this closes this issue with that angle. But then from that time on, we should then be using a tracking mechanism that's going to make it possible for us to act at the end of the month or 2 months. There's still no response. There's still no action. What other action can we take?
Person, if it persists, we can write to the Speaker of Parliament, because then these municipalities and governments, local, provincial governments, would be in contempt of court, contempt of Parliament, because according to the Powers and Privileges Act, because you can't just ignore Parliament when they ask you for things. I mean, it's unheard of.
That I agree. I think let's tabulate all of these issues as the concerns as we adopt this report with a particular way forward, and then start acting on all of those issues. 𝐼𝐶𝐾𝐿.
We can also do you can do a press statement as the chair on a monthly basis or what, and say these are the following municipalities, because they are accountable to the public. This is not only about us. We are doing oversight to make sure that services are rendered to the public. When they don't report to us, it means that there's something wrong. So we can say these municipalities appeared before the committee. We requested these reports. We didn't get feedback from them. Let the public know that the municipalities are not giving feedback. We will definitely get some reaction from public, and they will get the most probably some pressure to perform on these things, because that is what we want. We want them to correct the things that they are not doing right.
Okay, that's a good point. Let's add that as some of the actions, and then we will then start acting on all of those. All right. So thank you very much. Do we then have any issues that need to be corrected on these reports? Can we accept it as it is with the various disclaimers that we have just tabulated? No objections? All right, please tabulate that now.
No objections, Chair.
Thank you. That means both the reports will have the same issues added on them. In terms of what we need to do, one, we need a tracking system that must be activated at the point of the meeting so that they can always pop up to indicate that there's action expected. Two, that we're going to have a monthly checklist that basically indicates which municipalities or which departments were expected responses from, and whether in fact those have been received. And this must be an addendum to the discussion on the program, so that once in a month we've got a sense, we keep a track of all the activity of the reports that would have arrived from the various municipalities. 3, that when there has not been a response from the different municipalities or even provincial executive, we will then we would then write the letters to the Premier, the Speaker, and the Portfolio Committee and the MECs to explain why there have not been any action if there hasn't been. And then fourthly, with that report, with those reports, we then can escalate the matter to the Premier, to the Speaker, to indicate that there are those particular areas of lack of compliance from the various provinces. And lastly, also then issue a statement to the fact that there has been defaulters in submission of the expected report. I think if we look at the 2 reports and put those as our riders on, we can then close these reports. But then within the next few days, let's say within today, tomorrow, let's send all these letters to all the offices that we've indicated. Then we'll see how this comes back, and then we can draft the question of the statement that indicates that we have now written to them again. They have not responded as they were actually initially asked to submit certain reports, and therefore we are expecting them to explain. That will now cover for both KwaZulu-Natal and the Eastern Cape. And we then adopt these reports as reports of those meetings, but that there's a lot of work that still needs to be done so that we've got a better sense of the status of service delivery in those municipalities. I think if we can deal with those 2 that way, then it deals with the first aspect of just how to deal with the management of our own records and then subsequent activities going forward. That's fine then. I don't know if members would like to have a look at the other report, or we can just take the same approach on both, or if there are concrete issues where you think you need to get them corrected, then we can pick those up. All right, that then I think should deal with both the report to the Eastern Cape and KwaZulu-Natal with those conclusions. Please show us your agenda again.
Chair, I support that approach for both provinces.
Thank you very much, Honorable Mtolo. Now, that brings us to the end. You need to just show us what's going to be the next engagements. Shireen, do you have a program? Sorry, Shireen. Sorry, I was muted. Can we get the program for the next aspect of the committee meeting? Please mute. Please mute. Yeah. So give us, Shireen, give us the program. And Honorable Ndamase.
Thanks, Chair. Just to reiterate it in the meeting, I had long said, Chair, as far as I'm concerned, the Wednesdays, They clash with the Portfolio Committee on Public Service and Administration. Always my apologies. We had agreed about this in 2024, but I can see that it's changing now, and there are several meetings that come on Wednesdays. Thank you very much, Chair.
Apologies. The only problem is sometimes that's the time we can get the minister. And in this case was the situation. We'll avoid as much as possible, but we note that. Members, that's what we're going to be dealing with tomorrow.
Chairperson, the meetings for Friday. So the meetings for Friday, there was 2 invitations to the committee. So one is from Home Affairs on the electoral reform consultation report. And there was also an invitation from the Human Settlements Committee on a petition. The petition that was sent was to intervene in a request to upgrade a site or resettle people. That petition was sent to Human Settlements, and according to the ATC, they have to confer with us. So they invited us to that meeting for Friday. So I'm not sure if members can indicate which meeting they want to attend, or if we as a committee is going to agree which meeting we would like to attend. And then for the following week, we have meetings, joint meetings with SCOPA, and that's also where the Wednesday meetings comes in. Mostly with joint meetings with SCOPA, but for the committee, we try not to have Wednesday meetings. It's just when we meet jointly with SCOPA. Thanks, Chair.
All right, honourable members, let's note that, and members, please indicate which ones you'll be able to attend. Are we supposed to choose on the Friday one or the other? Or we just need to split the Honourable Francais?
Thank you, Chairperson.